Hence, we are of the view that such conduct of the state authorities, styling the appellants as contractual employees for years together and dividing them from becoming permanent on such plea amounts to unfair labor practice. According to the writ appeal, number 3071 of 2023 is allowed and disposed of. Consequently, the writ appeal number 296 of 2025, preferred by the state respondent, stands dismissed.
I agree. A good judgment, youngsters may read it. My brother has taken a lot of things in crafting that judgment.
No. Kindly, annexure 3 please. Your representation you had written.
Even his prayer he does not read. In his prayer he has mentioned that judgment.
Second paragraph, last line.
Short grievance of the petitioner as to non-payment of arrears schedule, which he says that the same has been written during the period between 10 2017 and 14 and 2015. But the counsel for the petitioner submits that we have made a representation dated 16/9/2023, and if a direction is given to consider the same justice to his client. First, with the above proposal, Mr. Lagnity GFE appearing for the OPC is agreeable, subject to the period that all contentions should be kept open and the reasonable period be granted for consideration. Next one. Okay, please. All contentions discussed. Item 14, presentation to be considered in the light of each matter of exporting Item 14?
Item 14 is my item. Representation under Annex 3 is pending.
Huh?
Item 14 is the matter.
So you are 14?
I'm 14.
Okay, you came in advance, put there or something.
I'm sorry. Here in the Annex 3 is the representation pending.
Representation for what?
This is a representation for conducting inquiry because it's a Panchayat High School. And the petitioners are the.
Who are you?
I'm the Sarpanch of that Panchayat. Now, this particular person who was employed as teacher, now his certificate in one of the RTIs, as furnished by the university, it says that he has not qualified the BEd course. Now, subsequently, there is another RTI which says that he is qualified. Therefore, I had represented before the district education officer to carry out an inquiry. That is under Annex 3 series, page 13.
The short grievance of the petitioner who claims to be a sarpanch of the Gram Panchayat is as to non-consideration of the representation dated 6/9/2025 and other as an example 3 series, wherein he has requested for holding an inquiry against the OP number 3 for the misconduct of producing the fake certificate. First, the consent for the petitioner submits that if a direction is issued for consideration of the subject representations, justice will be to the client. First, with the above proposal, the G appearing for the OPC, subject to the caveat that all contention should be kept open and a reasonable time period be granted for consideration of the subject representation. First, this is there. It is. Item 15. Item 15.
It's annexure 12 is the impugned order, my lord. Annexure 12, Lordship may kindly 10/6/2025.
When is the judgment,
So cause
the coordinate page?
yes, you want the passing of that order. How such an order will be passed?
Then that is the problem. Go to the prayer. Was he not a party to that proceeding?
No. He
Then,
he himself has come up.
Famous judgment, Shivdev Singh versus so and so, state of
My lord,
Punjab,
State of Punjab,
63 Supreme Court.
that may not be binding on him, but
That's what, but he can seek review.
Review of-
Take out 63 Supreme Court. Anybody? Shivdev Singh versus Dr. Chuli,
Sukhdev Singh.
63 Supreme Court, 63 or 64? Shivdev Singh, 63 Supreme Court. You take notice, Mr. Ji.
My lord,
Ji is requested to accept notice for this. What? Item 16 is this notice is issued keeping in view the apex court decision in Shivdev Singh versus State of Punjab, year 1963 SC. This is a by judgment decision. Next. Item 16.
16 manner on behalf of Jenna, the Lordship pass after launch 16 and 13 and 52 after launch manner. Over telephone is instructed to for
कौन मैटर था देखिए तो मैं देख
over phone.
आफ्टरनून में पुणे अन्य लिस्ट अच्छे ना
Ramlal,
रामलाल केस
take notice.
my lord.
Take notice. Look, it is requested for example.
रामलाल
Notice to 6.
रामलाल
Next.
Item 17.
Item 17, Hemant Soto, similar matters. Similar other matters, my lord, 74, 77 and
अरे गोटोटा आसु
same similar.
अरे सिमिलर जे सीरियल नो आसले हमको असुविधा होचे
So they can
couple.
no.
लिखी दी थी आयोग के देते
Number is also Follow. 17, both are same.
both are same.
yes.
Yes.
Item 18.
Not in this case, if a town planning authority without any notice of the landowners and the co-share of the property, they acquire the land and for town planning purpose. And they notice the dead persons. Only seeking to a fresh demarcation and carve out the whole plot and they acquire only 40% of the land.
They asked you to relinquish that now.
Already they notice to relinquish. And so
Take
on.
notice.
Yes.
Issue emergency. ATA requested to accept notice to 1, emergency notice to 2. All.
Item 19.
In this case, the petitioner, where the grievance before your lordship that he has applied for certified copy of judgment and decree of from the civil court. Civil court referred to the records transferred to another court. Another court he has applied. The ASCA court says the record has been consigned to the record room. When the petitioner applied in the record room says that has been transferred to the appellate court. By this
So
process,
you are not getting the copy.
copy will
You want copy.
copy.
At whose hands you want it? Mr. G, who appears for the registry?
We are appearing.
You are appearing.
Yes.
Take notice.
My lord.
Notice.
My lord.
G requested to accept notice for opens. Better late in rather from first calling the first week of January. Okay.
Item 20.
Notice.
This is that concern
Consideration of an exact breach.
annexure 3, my lord. That term.
Serial number of 2
Yes.
system. Yes. See that serial number.
That is 13, my lord.
13.
Representation of the
Consumption. Representation dated 18. It's also. Yes.
Item 21.
The petitioner has read for rehabilitation appointment under 1990 rules, similar rules.
Copy the copy. Where is your representation?
Under annexer, was 8.
This order, I don't think, this is not a good order. That will not help you.
Yes.
So it was some better order.
Yes. Positive.
Short grievance of the petitioner against the wrong pendency of the application for appointment at the rehabilitation assistance scheme rule 1990. First, learned counsel for the petitioner submits that applications of the kinds have to be disposed of on a war footing in view of apex court decision in
This is my lord Jittalu.
Safety versus State of Orissa. Civil appeal number 4103 of 2022 decided on 20 May 2022. There is force in this submission. Next, the appeal Mr. Monty in his usual fairness submits that if a reasonable time is granted and all contentious are kept open, there would be no difficulty for considering the subject of the petition in a time bound way. First, something the petition in your above 6 months. All contentious can. This will be good on.
This will.
Of course.
Item 22.
22.
Yeah.
Although it is a rehabilitation assistance case, my lord, the name of the petitioner find place in the provisional merit list after scrutiny everything, my lord, at serial number 1
Where is your
under annexure 8. my lord.
what case is recommended?
My lord, yes, my lord.
Recommended by who?
By your lordship will find the final merit list was published by the district education officer Cuttack by letter dated 24/6/2025. But what they did, my lord, in under annexure 9, they issued a letter only 28% name was indicated to come and get the appointment. Fixing the date of verification of
That
certificate.
notice you are not received.
My lord, it did nothing, my lord, no communication to. They are only saying that, assuring that, yes, we are considering, we will give you engagement.
Not that there must be a document verification or any need of the things. So possibly,
Do that exercise.
They have verified the document
Short
and found correct, my lord. Only.
Short grievance of the petitioner is as to non-consideration of his case for compassionate appointment despite a recommendation in the form of final select list dated 24/6/2025 issued by the district education officer at annexure
At annexure 8, my lord.
at annexure 8. First one. Let the counsel for the petitioner submit that although notices are issued to similarly circumstanced persons for verification of records, etc., similar notice has not been issued to his client.
No, my lord, verification was over on that day. But they issued the annexure 9, calling them to get appointment, receive appointment.
But the counsel for the petitioner submits that despite verification of the records, no notice of appointment has been issued, although similar notice, such notices have been issued on 4/10/2025 to other people, as is reflected in Annex 9.
Those were junior to me. I am in above.
He adds that the said noticee happens to be junior in the final selection.
Yes.
Final
Lord, RA scheme they have applied for. It's not a question of junior senior. Similarly situated.
The select
In the
list, there
preparation.
may be out of it. Submit that if a direction is given to OP number,
OP number 3, my lord.
OP number 3 to accomplish the task in a time bound way that would do equal justice to subject AG is agreeable, subject to the caveat that all contention should be there, and a reasonable period be prescribed for accomplishing first next one. The above circumstances 6.
My lord, it's hot date, main, but it's hot date because the very biggest.
What it took selling,
Final
no?
order.
My lord, my lord.
Next. Order 23.
I have filed a representation before the opposite party to
For water supply.
water supply.
This is in respect of the water connection to the.
Water is a need, necessity.
Yes, ma'am.
124 of 24.
Yes,
124.
yes.
Hmm. 197 of 2020. Yes. Yep.
Item 26.
The petitioner entered into a government service and laboratory assistant. The year
What is that amount? 4 lakh?
amount, my lord, yes, my lord. Amount sanctioned 9,48,940. But the authority deducted 4,12,900.
Where is your representation?
Representation by annexure 4, my lord.
It's in your local language.
Local
Local
language,
language.
my lord, at page 12.
You release that money.
Yes, my lord.
Short grievance of the petitioner in respect to the non-conformity of his representation dated 17 by according to the Supreme Court of Challenge. First. Counsel for the petitioner submits that in the said representation, his client has requested for leave of the amount which has been unjustifiably withheld. And the said amount is quantified as some more than 4,10,000.
Sorry, my lord. 13,61,000 sanctioned.
No, in your prayer you have said 4,12,000.
Deducted 4,12,900.
That is the representation also. The amount so admitted, that is 4,12,000.
4,12,000 deducted.
OP number 3.
Submit consent for the submit consent for the petitioner from the federation will be issued to OP students because the subject of the education and for the justice should be done. Lovely DG appealing for the OPs, although initially it mentioned that matters like issues will be relegated to the civil suit. Come on, now very clearly agrees that OP number 3. 3 look into the grievance of the petitioner evaluation of their representation in accordance with law if a reasonable time is given. First, this is the petition. 8.
Item 27.
Here in this case, the petitioner initially for some.
What is that order 19 to 25 hours?
Minor? Last order. 19 to 25 is the suspension order, madam.
You are under suspension.
Under suspension.
19 to 25.
Minor.
And
And,
inquiry is going on.
Charge has already been framed. I have directed to file show cause. We have already filed the show cause.
We need them to consider whether it should be rescinded in the light of Ajay Singh.
Till date, Ajay Chaudhary.
Ajay Chaudhary.
Till date, no suspension allowance.
Substance also
No.
given to you.
No.
Then take notice. Issue emergent notice.
Sir, my lord, register Utkal University.
To 1, emergent notice 2.
2 and 3.
Matter lies in narrow compass, call the second week of January 2026. Item 28.
My lord, myself, Advocate Sundarani Pani from BC Barampur, my lord, and it is a claim of RACP, my lord. Several identical cases already payment has been made, office order passed, that is annexure 2, 3, 4, 5, 6, 7, 8, my lord. But my case, as per annexure 10, they rejected, my lord. Though identical case confirmed before the Supreme Court, my lord, as per annexure 11.
OP number 1.
Yes.
Emergent notice 2, 1, 2, 3.
Here, my lord, 1, 2, 3, I can receive. 2, 4.
4 notice. Yeah, emergent notice 2. Next. Item 29.
The petitioner challenges the inaction of opposite party. Number 4, in considering an application on the rehabilitation assistance scheme, my lord. My lord, similar order not say passed.
Your annexure is dated
This is dated 9/2/2024, my lord, at annexure 8, page 23.
9/2.
2024, my lord, as it is available.
You should change your factor, change and you are somebody will guide you. In factor should be changed in that, na? Then we can make the order.
My lord, lots of
Ask somebody who will be sitting covered by matter.
देखिए
Brother, just advise her how to change that. Factor, so take us. Yes, Mr. Moses, this follow.
No, my lord, in this case, repentation 9/2/2024.
That you have to write. There in the column, you have to write that, so that will be printed.
Here the by instruction, lordship on direction to OP party 4, OP number 4, my lord.
Okay, number 4.
Yes, my lord, in this case.
All.
And the petitioner's father was peon, my lord.
All. Next. Item 30.
Replaced.
Please doing the work of the petitioner's counsel. Give them. Take that. Yeah, take that. That's looking. May not be proficient lawyer. That's you looking. Yes. Next.
Item 30, my lord, in this case, petitioner paying for passing of the office order issued dated 13/3/2025 issued by the government, state government, office department 1. And pass in order for direction may be given to the party to payment the 2 advance increment in favor of the petitioner. As per the government resolution dated 31/12/1999. Annexure 4.
Advance increment needs to be granted. Saying that there is no provision at all.
At the end of the mid PhD, they have done it for that. Let notice go will file the counter, by that it will be reflected.
Yes. Item 31.
May I pray, my lord?
Yes.
Lord, in this case, my lord, the opposite party number 6 purchased the land, my lord, in the year 2016. And your honor, kindly see page 58, my lord. The declaration, my lord, he has purchased the land along with a building, my lord. First floor 600 square foot and first floor is 544.7 square foot. And there are,
That order now, you want
my lord, I am challenging the order page,
10 to 25.
my lord, what, annexure 21, my lord. That is the order of the appellate authority. Set aside the order of the commission of the municipal commissioner with regard to the illegal construction, my lord.
91(2) it is.
My lord,
Section 91(2).
it's 912, my lord.
You take notice.
Serve the copy because I don't have any file. Possibly.
We have shown. Mr. Mohan requested notice for OP numbers 1 and 2, emergent notice 2, 3 and 4, 3, 4, 5. And
3, 4, 5, 6, my lord.
8 to 6.
My lord, there is an interim application, my lord. With regard to proceeding, my lord, he is proceeding in
Application in IA number so and so supported by affidavit report seeking the free first counsel for the petitioner submits that since divergent findings are recorded, it is a fit case for deeper examination. First of, he also points out that if court election is not halted, his petition will become infectious. Having an loss in to there is force in this submission. Next one, double circumstance application. There shall be stay of court's election against the petitioner pursuant to impugned order dated.
impugned order dated, my lord. 10 to 2025, my lord.
10 to 2025, copy whereof will settle in the 25.
Well, God bless.
Something already granted and content to might be open to the jurisdictional office to seek its variation record. If grounds to accept their
God bless.
Item 32.
My lord, petitioner was initially working as Gana Shikshaka. In challenging the order under Annexure 1, his case was regularized on the grounds that he has passed OTT on 9/1/23, my lord. And
take notice. Because after more than 1.5 years, you have come to the court. Yes. Never get notice. All office.
Item 33.
Injection of RSV benefit under Annexure 19 is under challenge. That is on page 65, my lord. OP number 2, reject my case for granted.
Similar matters we have issued notice. Open of the request for notice 2 1 to 3, number 6 for 4.
Madam.
34.
Election of Shiksha, sir. The lordship already noticed a batch of cases, my lord.
That relaxation of the age.
Yeah.
For the Shiksha side.
For OPs, call this matter along with WP number 6.
Item 35.
Yeah. Next.
Item 36. Online fees, paperless.
But for other things,
Item 36.
36.
Grant of RACP benefit.
Yes, ma'am.
Well, where is the representation? Can I find it?
No difference, my lord, that one page.
But there are judgments which are cited.
Ashok Mahapatra. Let notice go, let them appear because no one is for the petitioner.
Issue emergent notice PG for office.
Item 37.
May I please your lordship? This is the matter relating to transfer of a junior teacher. After the judgment of your lordship's court, the petitioner preferred appeal before the director under Annexure 6 million. It is pending.
Appeal is pending.
My lord.
That is considered, that will do justice to you. We direct them to consider the appeal within 2 weeks.
Yes, my lord, but taking into consideration by virtue of your lordship's judgment,
our judgment here they have to look into.
20875 of 25 million.
25 subject to paragraph 7.5. 7.5.
My lord.
So the short grievance of the petitioner is consistency of his
5.6.
appeal.
7.5 and 6.
The transfer order dated 10/7/2025. First off, learned counsel for the petitioner submits that the matter is substantially covered by the judgment of this court in WP number
20875 of 25. Judgment letter 27/11/25.
And therefore a direction is issued to the appellate authority to hear and dispose of the appeal before long. First, there is force in this submission. Next, learned AGA appearing for the OP submits that there will be no difficulty in instructing OP number
2 million.
OP number 2 to dispose of the subject appeal if it is pending. In accordance with law, if all contentions are confirmed with the period is fixed. So, in the light of the cognate judgment, first this is failed. Next, the circumstances petition is disposed of, directing OP number 2 to hear and dispose of the appeal, keeping in view the observations of this court in the cognate WP within an outer limit of 3 weeks.
Item 38.
Please, Lordship. Lordship, this is a matter regarding
It
to.
can be viewed with serious in the next level of litigation. Yes.
Your Lordship, this is a matter regarding to engagement of Shiksha Sahak against backlog vacancy, which has been rejected under Annex 5. Similar matter, my Lord, so that it should notice.
My lord, that relaxation, 2 matters before that notice was
It may
issued.
be tacked up.
Issue emergent notice, follow along with WP number 7. Review of the expired reports.
Grateful, Lordship.
Next.
Item 39.
After launch, my lord, on behalf of SK Jana, my lord. 39, after launch.
After lunch.
Yes, madam.
Pass on.
Madam.
Item 40.
Item 39, that, my lord, this is second round litigation. The authority has rejected.
Notional service benefit to be given to you.
My lord.
Take notice.
That is Annex 7, my lord.
There is order which is rejecting the
My lord.
needs examination. Issue emergent notice.
There is similar order passed by this honorable court, which is annexed at Annex 8.
What they have said.
They have that in that case the petitioner has appointed in the
Annex 8 is the order of this coordinate bench. My lord, at page 45.
They followed Chandramani Jaina.
Chandramani Jana. And here let notice go, my lord.
Take notice.
Because,
Let us- Matter lies in an honorable issue emergent notice. AGA 1 section 40 notice. Matter lies in a narrow purpose. Counsel for the petition that it is covered with the pending decision also. First one, qualification from January.
Item 41.
May I please, madam?
Yes.
The petitioner was placed under suspension without any proceeding petition approach this honorable court. My lord, disposed of the petition directing the authority to take a decision relying on their Chaudhary judgment, my lord. Now, my lord, they reinstated the petitioner revoking the order of suspension, but placing in a different place in obedience to the order of the administration. I joined there. I have already joined my new place. I only, my lord, if my lord permit, I file a fresh representation OP4. They will consider because 30 kilometer distance now they have posted me.
He has been reinstated all the way.
Where is the rule which says you should be reinstated in the same place?
My lord,
So that apex court say you have right to be reinstated. It is not that you should be given the same.
No, I'm not.
The inquiry is going.
I am not placing. I'm not praying for same. I only request my lord, say since they posted me 40 kilometer distance, and 3-4 places are the nearby institutions lying vacant. I may be permitted to file a representation to OP4. He will consider in accordance with.
Petition prayer reads as counsel for the petitioner submit that if liberty is given to the petitioner to make a representation posting in the nearby institutions
OP4
wherein vacancies do exist. First one, with this proposal, learned AGA Mr. Monty is agreeable. Since prayer is innocuous, first, in the above circumstances, petition is disposed of, reserving liberty as sought for. First, if a representation is made, the same shall be considered by OP number 4.
4, my lord.
4 within an outer limit of 4 weeks, keeping in view the policy guidelines and other factors. All conditions.
My lord.
Next.
Item 42.
Here, my lord, my rejection. I am challenging the order of rejection for regularization. They rejected Annex 12, my lord. Petitioner who was a person of the advertisement under Annex 1 in the year 99, who applied for pilot.
Take one.
Item 43.
APA for
All my lords.
all.
All my.
Item
May I
43.
please? My lord, matter relating to selection of LTI, physical education teacher. Here the petitioner challenges the improper evaluation and the answer option given by the opposite party.
Question 21 and 40.
My lord,
What are the details?
21, the lordship will find from page 51. Starts from page 51. This is the answer booklet.
What is the question? What is the answer?
Question
Page
number
52.
Page 53 is the question number 21. Which objective is not given by National Plan of Physical Education and Recreation? There are 4 options.
Development of emotional stability.
My lord, development of organic fitness.
The ABC. D appears to be the answer.
My lord. But in the tentative answer key,
they have given A.
A. Subsequently, that has been changed. Again, that has been revised 2 times.
Take notice.
Here, my lord, staff selection is there.
No, even your key answer appears to be wrong.
They are to answer, my lord. Odisha OP number 3, my lord.
I will serve a copy.
They are the panel of lawyers. 1 and 2 I can accept.
1 and 2. Emergent notice to OP number 3. Who appears for OP number 3?
Sanjeev
Panel concept so himself requested to accept notice for OP 3. Petitioner to serve copy of the petition along with the documents on the said panel consent within 3 working days. Next.
Item 44.
Another coordinate measurement. Current relief integrate.
Prayer is same.
Yes, same.
That is gratuity last week, my lord, sir. Paste the the item number 39, which my learned senior sought for pass over, my lord.
Same.
It needs no, my lord. It needs to be notice to be issued because finally order has been passed in Annex 9 again.
That password matter was there, na? Item 39. Issue emergent notice. Let the AGM is going to be requested to accept notice for all OPs.
Yes.
Yeah. Next.
Item 45.
Yes, Ms. Priyanka.
Recap number 197. Right.
We have copy of subject to outcome.
Yes. Recap number 197 by 24.
This subject is subject to outcome of the appeal 197 of 2024 between state of Odisha versus
Hemant Kumar Chotra. 46 also same.
46 also same.
46, 48, 49. That's
46, 48, 49. Yes.
Item 47. Item 47.
Fixation of pension. So no reprinters are filed. Notification notice.
No, they have reproduced a resolution.
Yes.
In terms of resolution, if they make a representation, you consider that.
Yes, yes.
But short prayer of the petitioner reads as an first. Counsel for the petitioner subjects that the prayer is supported by the resolution of the government dated the 19th January 2009.
19th January, madam. 2009.
A copy thereof avails for collector 3. First of 50. Learned AGM Mr. Lenka opposes the petition, contending that the petition is not preceded by demand and rejection, and therefore petition should be rejected. But having so said, we very fairly suppose that if the petitioner gives an appropriate representation with full material particulars and the working document There will be no difficulty for considering the same in a time-bound way and in accordance with law. First of all, next one, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to make appropriate representation within a period of 3 weeks, and if one is made, the same shall be heard and decided within an outer limit of 6 weeks. Next to following, first of all, contentions are tabled. Next.
Item 14 have been disposed of. Item 50. Item 50.
It's be number 39 of 2023 in CLT. Pass over.
Item 51.
Lordship, here the petitioner that is claiming his promotion. The particular rules that is available under Lordship, that is nomenclature as Orissa Education Recruitment and Conditions of Service Teachers and Members of the Staff Aided Education and Institution.
Where is your representation?
Lordship, my representation, in fact,
series page 9.
in fact, Lordship, it will be the first case of the state, Lordship, because now they have not granted. Lordship, can you come to page 22? Though while disposing other writ applications, the authorities, Lordship, have in paragraph 3, Lordship, last line, they have held, Lordship, assistant teacher of UPME school can only be promoted to the headmaster of that specific school subject to BA and BSc BD qualification and vacancy. All the qualifications I have, Lordship. But perhaps it will be first case because they have not granted any leave to any of the person of the state.
Take notice.
Lordship, they let them obtain instruction letter to come in fresh admission, so that, Mr. Lordship.
Issue emergent notice to encourage notice for rules. Matter lays on an arrow. First class is matter in the second week of January, third week of January 26.
Lordship,
Item 52.
Also, my lord, on behalf of SK Janna.
The representation here is pending, my lord. Annexure 10, page 48.
Then your lordship dispose of the repension. Putting your lordship's prayer, my lord. Your lordship's prayer.
Petition prayer reads as that. First, petitioner has made a representation to the collector of the district at dated 7/8/2025, a copy whereof awaits at Annexure 10, wherein he has sought for modification of the condition imposed in the office order dated 27/5/2025. In the light of a coordinate bench decision in WPC 33272 of 2023 attachment. First, the counsel for the petitioner led in the direction which issued for the petition of the subject representation in the time of justice would be meted out to his client. First, with this proposal, the AG appearing for the notice on request is agreeable, provided that all contents are kept open in a reasonable period. First, the opposite case.
Obligement.
Item 53.
Lord, the petitioner appeared at the annual HSC examination 2025. Your Lordship may kindly turn to Annexure 3 at page 21.
You want rechecking and reviewing?
No, my lord, I am not praying for rechecking. Your Lordship may kindly see there is a mistake in addition of marks, page 21. On the face of it, your Lordship may kindly see, so far as question number 1 is concerned, I have secured 9 marks. Question number 2, 5. Question number 3, 6. Question number 4, 7. Question number 5, 4. Question number 6, 9. Total comes to 40, but I have been awarded 38.
It should be 40.
40, but I have been awarded
2 is missing.
2 is missing.
Issue.
But I will serve a copy on Mr. S.S. Rao,
Rao's panel,
who usually appears for the board. In similar matter, your Lordship.
All this matter along with, there is one more matter.
Yes, your Lordship may kindly see.
So, in the second week of January,
yes,
so apparently there is mistake. Yes.
Item 54.
Item.
No, arithmetical mistake is there.
Arithmetical mistake. And in some objective type questions, my lord, he has got less marks.
Let us. Yes.
Item 54. That is not same, but in some objective type questions, he has got less marks. I will survey copy.
Copy of the petition along with documents from the third week, second week of the. Yes.
Item 55.
This is second joining of the petitioner. The regulation of the service of the petitioner has been rejected under Annexure 16, my lord.
How many years of service he has put in?
Initially he engaged prior to 12/4/1993.
12/4/93?
Yes.
Rejected on what ground?
On the ground, it was Annexure 16.
What's the ground?
Ground, in the meantime, in 2023, the regular post has been abolished by state government, and while the other similar situated,
they have been regularized.
Yes.
Whether the other petitions where you were not the petitioner earlier?
Yes.
In WPC 17283 of 2016, etc.
I am in, I approach this Hon'Ble Court in Annexure 15, my lord. WPC number 15493 of 2025, page 79. This Hon'Ble Court directed to dispose of my representation in the light of Happy Dengua case.
They say posts are abolished.
Yes, my lord.
Take notice.
Yes.
Issue number 1, 2, 3 and 4. State is 3 and 4. Okay.
Also, all the matters
same.
Yes.
Item 56.
56.
Petitioner's actual surname was Rasmita Nayak, but in the birth register, wrongly has been mentioned Rasmita Sahu.
Surname of petitioner?
Rasmita Nayak, wife of Muna Nayak, but wrongly has been mentioned Muna Sahu.
Who appears for the vote?
CTP, so already completely CTP, open number 1. So medical, so lordship,
we can consider that
liberty may be given to file the reprint for the
petitioner. The consent for the petitioner submits that. Permission is given to consider the petition at the hands of justice will be Mr. Lenka appearing for the vote. Suppose it is a petition that the petitioner opposed the petition contained in that made by the person. He adds that the petitioner gives an appropriate representation supported by evidence in the motivated to support the same in accordance. There is what will be in the opposite circumstances. Petition is this word of reserving liberty to the petitioner to make an appropriate representation. As indicated above, and if one is made, the same shall be largely decided within an outer limit of 4 weeks. All contingent. Yes.
Prayer may be good.
Yes.
Item 57.
Covered by Saraswati Boy's case. I have corrected all the
factors.
Yes, yes.
Item 58.
Petitioner duly selected by selection process, appointed as co-commandant since 2008, and prayed for regularization, and he has made a representation on Annexure 6, page 23. The taking into consideration Annexure 4 and 5. Similar matter.
You have appeared.
No, I have not. Earlier,
The other case.
other cases they have been going to be implemented.
In the light of that, your representation is considered.
Annexure 4 and 5.
Annexure 4 and 5. Dated.
My representation is at Annexure 6. 16/2025.
Short grievance of the petitioner is as to non-consideration of his representation dated 16/4/2025, wherein a request is made for regularization of the service is laying out for coordinating decision in WPC number 2040, WPC number 8032 of 2023, this code of 2023. First, the net counsel for the petitioner submits that if a direction is issued for consideration of the subject representation in a time bound way, justice would be meted out to the first one. Learned the EGA appearing for the UPs and very fairly submission that you would instruct OP number
3.
to look into the grievance of the petitioner as has been heard in the subject representation in the light of a cognate decision, if all conditions are there. And there is just a very good 6 means.
Taking into Annexure 4 and 5.
Yes, sir.
Annexure 4 and Annexure 5.
The order set Annexure 4 and
Annexure 5.
Annexure 4 and 5.
Objection.
Item 59.
May I please, my lord? Earlier, my lord, matter was before the Law and Tribunal. There I succeed, my lord. Matter was when that was challenged by that one Susmita Naik before this honorable court. That was also dismissed. This honorable court directed you verify the records. Now government rejected on Annexure 11 on the ground that since I was appointed after the cut-off date, my lord have already decided that cut-off date is only applicable to the institution, not the person. My lord have recently decided.
Covered by judgment. Cut-off date applies to institution and not to the appointee.
Here your lordship may can see
You take notice
representation
and
yes.
to take note. Counsel for the petitioner submitted the subject matter is covered by the decision of this court. In FAO number 615 of 2019, decided on 2011-2025. First off, in view of that, call this matter in the 3rd week of January 20. Yes, next.
Item 60.
Password. Password.
Password. What is the prayer? Just read the prayer.
There is a claiming for promotion from label 5 to 4 and 3, madam, which was rejected by the Annexure 13.
Rejected?
Rejected, the
issue notice.
Promotion cannot be given retrospectively.
Issue notice, AGA requested also for this quarter.
Second round.
But 1, 2, 3, 4, emergent notice to file. Okay.
Item 61.
It is well working as level 3 headmaster. By the Annexure 1, page 13, who was deployed to another block. Kindly see. On date 1 to 1st February 2025. Accordingly, in obedience to that order, he accordingly joined my lord. Next page, Annexure 2, my lord. Thereafter, he made an application before the district education officer with some difficulties. Thereafter, his deployment order has been revoked, my lord, by Annexure 3, page 15 on 28/11/2025, my lord.
Now what happened?
Now thereafter, he joined in his parent post, my lord.
Yeah.
While he is continuing joined on, my lord, 2/12/2025, my lord, this month. After 10 days, again that order has been cancelled and directed to join in the deployed place by Annexure 6, my lord.
Why so much jantar mantar has happened here?
I can't take insurance.
Issue emergent notice. Petitioner has moved an application in IN number 22341 of 2025, supported by an affidavit taking reprieve against the impugned order. Personally, this is made out about 1,003 regarding the taxation of events that have happened added to measure of the demonstrated agency and injustice. The impugned order dated
10/12/2025, Annexure 6, page 19.
Then 6 is hereby state. Next time, it is open to the notice to see the variation of this order. If you don't do it, this day one. Okay.
In course of development.
Item 62.
Within the stipulated time of 8 weeks, my request has not been considered by the police notice.
I'm preparing for 55 minutes.
Let police notice go, then now you can't appear. Issue police notice to do this. Police should go there along with party, things will happen. Yeah. 62, 63 is same, 62, 63. May not complex.
Item 64.
Mr. G, you should, Mr. Monty, you should instruct your officers to comply with the court order. I will be very wild.
We are doing it, my lord. My lord.
Yes, first duty is to comply with the court order. Yes, 64 also, minus 63, 64. Same. Okay.
62, 63, 64, same.
Item 65.
Complied in WPC number 23967 by 2025, disposed on 9/9/2025.
What was the delay? 2 months are over now.
Yes, madam.
Police notice. Police notice. Yes.
Item 66.
Item 66. 8 weeks was granted.
They have not done that.
No.
Police notice.
So far the open number 1 is considered, my lord. There is no direction to the open number 1, my lord.
To whom it was issued?
But it is issued to the university authority, my lord. Utkal University Authority, my lord.
Police notice to 2, 3, 4. Notice to 1 is dispensed.
Item 67.
In all the matters.
In all the matters.
My lord, the petitioner was engaged as a physical education teacher in the year 2013. Since he was not regularized, he approached this honorable court. This honorable court directed that you make a representation. I made a representation, the state government rejected it. I have come here. Your lordship directed them to file a counter. They have not filed a counter yet.
But then the
Connected filed within 3 weeks, spelling which petitions have been taken with the base level. May be taken with base level. Call it the second week of January 20, third week of January 20. Okay. Next.
Item 16 has been adjourned. Item 69.
Yes,
69, my lord. My name has been recommended by the governing body and was recommended by the sub-collector. Now I file a representation annex to 12 that is pending, my lord. By the for my consideration verification for the purpose of salary, my lord. Again, in the post of lecturer in education.
Salary is not paid.
Salary, my lord, I was appointed as a demonstrator. So demonstrator person, he died, my lord. Governing body recommended my name.
For appointment as demonstrator.
For consideration my case in the post of lecturer in education, my lord. That was forwarded by the sub-collector. Now direct I have filed a grievance before the OP2, my lord.
Petition prayer is added. Counsel for the petitioner clause.
Lord, his post has been approved in the post of demonstrator, my lord.
Yeah.
He is praying for the post of lecturer. My lord.
Consider. If it is rejected, well, it would have another cause of action.
My lord.
Counsel for the petitioner draws attention of the court to the recommendation made to it under the relevant dated
16, 12,
No, my lord. 23, 9, 23, 9.
23, my lord.
23, 9, 33.
No, 28 to 2020.
28 to another. Oh, the recommendation.
Recommendation is what?
Lordship.
Page 31, my lord.
I am for
31.
Page 28.
28 February. No, it may not be.
My lord, it was sent to the director, my lord.
No, that is your, it is not your representation.
It is, my lord, it is, my lord, to the director, my lord, by the principal.
The principal has provided. 32 is the representation of the petitioner. Page 32 is the petition.
No.
So the representation that has been provided.
Petition. Counsel for the petitioner submitted that the principal of the institution, letter dated 20/2/2020, has recommended case of the petitioner to the director, interest education. A copy whereof arranged that an experiment. So representation dated
23rd of September 2024.
2024 has been given. The same remains until the date, and therefore interference of the report is warranted. First, next one. The DAC is the same. Again, for the opinions of the opinion numbers 1, 2, and 4, the opposite applications containing that in the absence of a demonstrable right, relief of the claim cannot be done. First, having so contained, now we wish to instruct OP number 2 to look into the grievance of the petitioner as has been aired in the subject representation, keeping in view principal's recommendation in a time bound. First, this is the petition. Next one. 8 months.
Item 70 has been adjourned. Item 71.
Sir, item number 71, I'm praying for adjournment.
Yes, on the question. Yes, third week of
Item 72.
Ahmed Kumar Chhatla.
Ahmed Kumar Chhatla.
Block grant pension. This also. Have you changed the factors? Have you changed your representation in section? Representation. Good. What's the matters, Naila? Yeah.
Item 73.
He wants withdrawal of resignation. Whether it was accepted.
He has submitted the representation to the by managing committee, my lord.
Correct.
But
Before accepted, he has made the application for withdrawal.
the representation submitted to the government officials, my lord.
You take notice.
Lord, sir.
Yes, they is special consent notice for 1, 2, 3, 7, 10, 11, 2, 4.
74.
74 and 74, 77 and 90. All are
74,
74,
77,
77 and 90.
90.
Yes. All are Hemant Chhatla. I'm giving.
Subject to appeal. Yes.
Item 75.
Please.
Yes, sister.
Your Lordship, this is a case relating to selection for the post of TGT MAP under Odisha Adarsh Vidyalaya Sangatans. The petitioner qualified the written test and she attended the document verification and she was allowed to appear the interview. However, the Odisha Adarsh Vidyalaya Sangatan rejected her candidature on the ground that she doesn't possess the requisite qualification.
Take notice.
To both the opinions.
Can I come back in a couple of seconds?
authority to consider my case for the promotion, and the authority has rejected by the annexure 15, page 72 on. I challenge the rejection order, and the authority has given similar benefit to number of teachers. Rejection order,
Why rejected in your case?
Rejected on the ground that the rule is not applicable, but the same on the basis of the same rule that authority has given that benefits. Against that order, the government moved before this Hon'Ble Court. This Hon'Ble Court has dismissed the case. Again, they moved before the Honorable Apex Court.
Take notice. Next.
Item 77 has been disposed of. Item 78.
But here the contractual period has not been taken into account for the purpose of grant of pension and GPF. But this case is squarely covered by your lordship's order. I have corrected it.
Shweta Padma.
No, not Shweta Padma is pending before the Honorable Apex Court, relying upon SD Jayaprakash. Your lordship may kindly see the judgment of the Honorable Apex Court.
Just look into covered by the judgment.
Karnataka judgment went to the Honorable Apex Court. Paragraph 17 and 7 and 8.
Item 7.
The connected matter is also same.
77.
78 connected matter is also same.
Okay.
Item 79. Item 79.
Tarsim Singh. Similar matter we disposed of today, so 3 matters. Lordship. Representation.
Represented by 2/9/2024.
Item 13 and 12. 13 and 13. 13 and 20.
Representation between 2/9/2024.
Item 80.
Lordship disposal. 79 disposal.
Item 80.
Same.
Same.
Same identical.
Lordship.
The 3. 21 and 2022. Pass. Yes.
Item 81.
I am the holding party. I am finding the counter balance.
You are filling the contract. Notice was issued in this matter.
And I was the counter balance. I have taken the balance. Application.
I have received copy of the counter. That's why
Today I am filing the counter balance in the registry.
You appear for 3 or 4?
4 months.
4?
Yes.
Your name is shown.
Yes, madam. My name was.
Counter you filed it.
Yes,
not here. Counter to be filed within 1 week.
No, already today balance I am.
You have filed.
Today I am filing balance.
You filed it. Therefore, I am giving you 1 week time.
Yes.
Okay.
Item 81 would have, sorry.
Yes.
I was in another court.
Just madam, sir. I'm sorry.
He is giving counter to you. Look into that. We'll call this matter in the 3rd week of January.
How do we go to full
Second week of next.
Item 82.
Yes. This matter relates to reconstitution of the governing body of an aided Ayurvedic college. Well, here I am challenging the order under Annexure 8.
Take notice. Please request the notice for all office. All office. All 1, 2, 3. Emergency notice to 4.
Yes.
Notice to 4. Okay.
Item 83.
1 Passover kindly.
Passover, what did you tell? Consideration of representation. National Association.
No, Lordship, on the last occasion, my lord, decision directed that
One pastor, my lord.
provision of law, my lord.
Mr. Dali on Legon, you consider that representation and says there is no provision of law for consideration. Reject it. You can't keep it pending like that. Good. Short prayer of the petitioner means as under. First, the petition is preceded by presentation of the representation dated 27/3/2025, a copy thereof awaits the one, wherein a request is made to include District Cricketers Association of Korapur in the Subdivisional Athletic Association, High Court. First, learned ASC Mr. Sain, appearing for OP number OPs, opposes the petition contending that unless the right is demonstrated for inclusion as sought for, no writ petition is made. First, having so contended, now he fairly agrees to instruct OP number 3 to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law. Is law. First, all contention in that connection, he submits, need to be kept open. First, this is fair. Next one. 8 weeks.
Item 84.
Oblige. CMPL for CMPL for restoration of order dated 15/10/2019. My lord. Similar matter already restored though. This means
restoration.
Yes, my lord.
It was dismissed.
Yes, my lord. This small wrong.
2019 order.
Yes.
About 5-6 matters were there, na?
Yes, ma'am.
Similar matter.
Yes, ma'am.
Then we'll restore it, brother. On merit you will hear, you can't dismiss the matters for execution, etc. So many matters are pending. Why the judges should dismiss the petitions? No reason. Yes.
Item 85.
Restored. Yes.
Against the MSFC order.
Yes.
Now the crucial point here is these are like arbitration awards. My lord knows MSCFC Council. These are all manned by non-judicial officers. What has happened?
Members of the
bureaucrats. Mostly it's a committee with OS, like not the IAS. It's headed by an IAS.
State administration.
Yes. So the crucial point here is why this error has happened. We received, just 1 second. We received the notice of hearing after the hearing has happened and the order is passed.
Your Lordship, I am appearing for the opposite party number 2, first sub-item, which is for Gupta Power. Your Lordship, for your information, Your Lordship, this company has been admitted into insolvency on 26th of September 2025.
But orders are made when?
Orders are made, my lords, in 2021. In the lead matter, this court has protected in the interim. Same orders is all that we request in the other 2 matters.
Now, since the management and control is with the IRP of the company, we don't have instructions with respect to that. However, we were appearing for the previous management who was heading the company. Since now IRP has taken over and since matter has come after 2021 for the first time. So your Lordships will need some time to take instructions that what is the exact position.
Take instruction and come back.
Let them not press execution because our urgency is these are electricity companies.
It's not here.
My lords, we are electricity companies, Tata along with government shareholding. So public utility services. Now, my lord, may see the earlier interim order passed in the lead matter.
Issue a similar interim order and
same interim order. We are willing to deposit.
Settle.
Your Lordship, since my wakalat, our wakalatnama is there.
That's all right. But you want to put the award in execution.
That's the reason the urgency, my lord.
My predicament is that must have been filed by the previous management. Now, since it is insolvency, moratorium is there.
That makes no difference to law.
Moratorium is there. So, if the IRP is present here or his representative is there, then your Lordships will pass order. Lordships will keep it next week for execution.
No, for insolvency, my lords, we are not wanting any relief against them. We are not proceeding to recover money from them.
They present in the court. Let the orders be passed. I am having no difficulty. Let it be kept next week.
Next week, let him have a consultation with his client.
The only predicament is because he is
But
heading the company now.
Next.
So it may be a difficulty for that.
Item 86.
Monday, my lord, for us.
Because he is saying something because of moratorium at 2017.
Let the IRP represent.
Lordship, sorry. Lordship, I'm extremely sorry. Lordship, extremely sorry, Lordship. Item 83. Lordship, disposed of my writ application was my representation to consider, Lordship, item 83. But Lordship, can you remember last day, Lordship, you Lordship direct me to produce the Lordship, the part of the basis to consider my representation. I have
Now I have disposed of that one.
Lordship,
Already printed.
only made 83, Lordship, just 83, Lordship. Only I pray, Lordship, this only affidavit, my contentions may be recorded, so that with some 83, Lordship. 83, Lordship, one matter.
Cricket Association.
Cricket Association.
We have kept all contentions open, that's all. In fact, writ petition itself is not maintainable. Anyway, I told him, he says, where is the demonstrable right at all?
No, in that
Anyway,
way,
all contentions
that I want to explain, Lordship, because they have taken decision in respect of others, Lordship.
Item 86.
My lord, I'm 86, my lord.
Yeah.
A talk of settlement is been going on. I pray that let the matter be taken after holidays. After holidays. After.
Next.
Item 87.
Item 87, may I please, Your Lordship? Your Lordship, this is for restoration of the original case, which has been dismissed for default, Your Lordship. The matter. Your Lordship, I have filed an IA for exemption from filing of certified copy of the order, Your Lordship. But in the meantime, I've already obtained the certified copy of the order.
Is the application for seeking restoration of that. The other court dismissed it.
Yes, Your Lordship. It was only listed for once. During the first listing itself, it was dismissed for non-prosecution.
It is on merits, sir.
No, Your Lordship. Or for non-prosecution.
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 Yes.
Yes, Your Lordship. Only once it was listed, Your Lordship.
At page 9.
What the time? 9.
For non-prosecution, but here there is delay.
How many days delay?
So, my lords, there is a private opposite party. Let notice.
Let notice.
Oh, yes.
Let notice. Notice. Emergency.
Item 88.
May I Lords. Sir, I am appointed as on the amicus curiae, but my name is Pikekar, but now AK has been reflected on dated thereafter purchasing. And thereafter also direct take notice. My employees have taken a notice, but now I found the no notice has been no request.
No notice is issued to
opposed by 2 and 3.
Since requisites for the same not filed.
My name is corrected, Miller.
For issuing notice. OP numbers
2 and 3.
2 and 3. First,
And my
to print the name of the council as
PK Garam.
files
Instead of AK Naik.
instead of files.
Okay, Naik.
Okay.
Okay, Gaurav.
89.
Item 89, Your Lordship was pleased to issue notice, Your Lordship,
89.
but the requisites were filed a little late, Your Lordship.
My lords, here.
Late fight that may be accepted, madam. We filed the requisites quite late. Requisite late.
Delay in furnishing the requisites is conduct. Registry to process is possible.
Item 90 has been disposed of. Item 91.
91. File the requisites by tomorrow.
Requisites within 3 working days. Yes.
Item 92.
Within 1 week.
Item 92.
Requisites within 1 week. 92. Notice could not be issued due to non-filing of requisites. Na? That's it. Yes, 1 week granted. Finally, failing which petition stands rejected. Yes.
Item 93.
Same order. 2 weeks.
Item 94.
My lords, here
There is a typographical mistake instead of
15, 10, 20.
my lord.
Where it should be rectified.
In the order,
In the pointed out that the wrongly 15, 10, 2025 has been printed as the date instead of 26, 9, 2025.
my lord.
Correct?
My lord.
25. First of registry to rectify the mistake at issue free cost of if applied for.
Item 94. Item 95.
Yes.
95.
This case,
I am appearing on behalf of the Staff Selection Commission. In both the cases, I have received the paper books, madam. It is a matter relating to re-evaluation of the questions, madam. So, my lord, I need some time to file the reply because the experts have to be consulted.
My lord, the second week we'll have it.
yes, only my difficulty I am facing now. My lord, I have kindly recollect in the page of cases last week when we hearing release all the posts to be appointed. Just asked it that page of cases. I have also selected. Only thing there are 4 questions I have appeared and I have answered correctly that I have demonstrated through the books.
Let him file up.
Yes, only thing my lord, because they are processing, can it be an earlier date so that I can have a chance to
The
participate?
vacation, you cannot. Put the vacation.
Immediately, because there will be no vacation bench, I think. Yes, that
No
was,
vacation bench in your.
I don't think it should.
No,
Small.
it's holidays. Normally,
Might be.
normally,
They may not have, no, normally it was.
normally, but sometimes.
Immediately after which.
Fine. First,
On the
second week.
ground of urgency needed. By me. Okay.
Second week, my lord.
Second week of the.
Fine.
Yes.
Item
Both the
90
cases same.
Yes.
Item 96.
96, my lord, noting is there that in order dated 10/11/2025, the IA number has been wrongly typed as 19810 of 2028.
It will be 25.
IA number?
19810 of 2025, it will be wrongly typed as 19810 of 2028. It will be 2025.
Typographical error as to the IA number to be rectified and rectified copy to be furnished free of cost if applied for.
Also, interim order to be continued.
Interim order to continue.
Item 97.
97, my lord, all these cases withdrawal. Also, my honored friend filed a petition in this case for withdrawal. On the ground, my lord, that it is not a proceeding under section 91, we have admitted.
He wants to.
But on conditional withdrawal, I don't have any objection.
Yes. Unconditional withdrawal.
Because it is a so-cause notice, and since our entire case.
Anyway, it is his right to file a case includes right to withdraw the case
Yes, but
also
I
because
don't
of
have-
Sheila Barsing.
I don't have any objection to that, my lord, on conditional withdrawal. My lord, I'll be pleased to record that, that is the.
With liberty to file a response, my lord. Since in the so-cause notices,
Petitions are permitted to be withdrawn with liberty to file a reply to the show cause notices, if any, if law permits, provided that the law permits.
that is there in the so-cause notice.
No, we
That-
do not.
Yes, ma'am.
Next.
Item 98.
Item 98.
Yeah.
Okay, number 9. Can you be taken up after lunch, my lord?
After lunch?
No, Mr. Mahanti is on accommodation.
It's accommodation.
For today only. So maybe taken up tomorrow.
Any urgency?
But my lord,
Matter pending.
my lords, the impugned order is passed by an authority of a corporation. So I cannot represent him. So my lords,
Has to go.
my lords, otherwise he may serve copy on the Penal Council so that
Issue.
five, my lord.
Issue fresh notice to OP number
5, my lord.
5. OP number
5 and 7.
5 and 7.
My humble submission, my lord.
Registrar cooperatives. Deputy Registrar is
No, my lords, this is Orissa State Civil Supply Corporation, my lords. He is acting. The impugned order is passed by him.
You appear for whom?
My lord,
My lord, my
I am for OP8. Counsel for the petitioner standing to kindly take the after lunch, my lord. Mr. Mahabati informed me, counsel for the petitioner, and take this matter after lunch, my lord.
What after lunch? Notice has to go. He cannot appear.
Yes, Lord.
Then I am the OP8, my lord.
OP number
5, my lord.
OP number 5 alone.
My lord,
OP
only
number 5.
I am for the OP number 9.
What's up? Going to appear for OP number 9.
We'll file B number.
I am at OP8, my lord.
To give them.
My power is there, my lord. OP8.
Your name is mentioned up?
Yes, yes. OP8.
my lord's 3 also.
3 also.
She is chief civil supply officer from estate manager.
3 and 5.
Man.
Yeah, emergency.
Item 99.
My lord's item 99. Your lordship kindly see the last order, but there is a government order prohibiting correction by the CDMO, my lords. I have taken instruction. My lords, kindly see the last page. That is why the CDMO has moved to the government for instruction, my lord. My lords, kindly last page. Last 2 pages. All the officers, CDMOs, are directed not to correct the once it is issued, my lords. So this is also communicated to the petitioner by the CDM.
No, nothing has been communicated.
Hey, this is this speed post. Speed post received.
Your client might not have told it to you. Now they are receiving.
No, I don't dispute me also.
Hey, received. Speed post.
After your lordship's order, look at your lordship.
After that.
Your lordships were specific that he should correct it because there is only spelling mistake, and if he fails to correct it by Monday, he should remain present personally in the court. In spite of that,
why it cannot be corrected?
My lords, so that government letter, my lords, I have given last page, your lordship kindly see. This is to all CDMOs. As per order dated this of family welfare, it is to inform you that once the green card is issued and accepted by the beneficiary, no further correction is allowed because it may create confusion.
What was the correction?
you only name spelling mistake.
Spelling mistake also will not do.
My lords, that is why he has written.
No.
Your lordship may say that. Your lordship may direct.
No, we have already directed.
Yes.
Where is that officer?
My lords, he could not.
Well, directly is arrested.
My lords, I'll ask him to present tomorrow.
Not tomorrow. At 2 he should come.
My lords, Parampur, it is a.
He was informed right in the earliest.
My lords,
Where is that direction, Mr.
My lords.
What
my
kind
lords,
of officers you have?
my lords.
They want to challenge the court's authority.
No, my lords. My lords, these doctors, they don't have much administrative experience.
No, there is an order.
My lords.
And I have threatened him.
My lords,
I have threatened him that he will be brought before the court.
My lords, very same day I communicated the order to the person.
Yes, you have done your duty.
And tomorrow.
So allow me to do my duty.
Today also, I have contacted him. I told why you are not coming. He thought that your lordship may call tomorrow. I'll make him present.
No. Otherwise, nobody will respect
my lords, I understand.
Therefore, let the SP arrest him. Bring him here.
One chance, my lord.
Which is the jurisdictional SP? Who is the jurisdictional?
Police Ganjam.
My lord, tomorrow 10:30 he will be present here.
Call tomorrow. Yes.
Item 100.
We also complied. My lord, complied after honorable court order. They are complied. My lord, this case is really
complied or not?
My lord, kindly wait. My lord, this case is without any application of mind, the OSD without any qualification, they selected. I have filed a case before your lordship.
Compliance is okay. If you are aggrieved by the order, You may challenge that order.
Sir, I have also one case is challenge and
Complaint
issue.
is reported, although belatedly.
Sir, my lord, I have
In view
also.
of that proceeding further. It is open to the petitioner to take up appropriate proceedings against the against the subject action, if he is so advised. Possible.
My lord, I have a rejoinder, sir. My lord, I have rejoinder. Yes, yes,
That's all. Read any standard book on law of contempt. Once it is complied with, maybe we delay. It is for the court to decide. Yes.
So one Passover matter.
Yes, Passover. Item 50. Pending before the NCLT. Probate for testamentary case is pending. Why we are also not here? For the council is not doing this status now. Let us see after maybe some urgency. First, let us see whether. Yes, start.
Quickly list item 2. Item 1 has been answered.
Yes, what is to? Yes.
In this case, I have challenged to the annexure 1, in which the realm of the petitioner for refund of EMD money or retention of the same for other allotment has been rejected. As per annexure 2,
your EMD is forfeited now.
They are saying to forfeit unless I.
Who appeals for the other side? Yes, what is your stand?
Development.
Yes.
My lord, despite several notices, he did not deposit the rest amount of the money.
Very
And did not
forward to
take over the
forfeit.
possession. Did not take over the possession, did not deposit the rest amount of the money. And the maximum period of action is 6 months. During that period also, he did not apply for action. And thereafter, as per the rules, we have to cancel the
allotment.
Hello?
Cancel the allotment and
Cancel allotment and the EMD as per the rule has been forfeited.
Which rule?
6 and 7 of the
Read.
Yes, true. I have voted in my counter, my lord, to 6 and 7 of the votes are put.
Use the book. Use the book to senior. Give photos. Rule provides for forfeiture.
Forfeiture.
Which is that rule? No, cancellation I can understand because he has not remitted the amount in time. But for forfeiture, where is the rules? Where is the rules? Read that rule.
I'm good.
Call up provocation to enable
Clause
counsel.
6 of the brochure, annex under annexure 2. Read. Was annexure 2.
What is the amount forfeited now?
1,99,000 some odds.
Where is the authority to forfeit like this?
Well,
You might have stated in your.
I'm reading clause 6.
That makes no
Page
sense.
17. Page 17.
That makes no sense. Unless the rule authorizes, merely by treating that condition, you cannot forfeit. That's the law. Which is that section in your where forfeiture clause is mentioned, how the apex court considered that.
No, the brochure.
What is that?
Then the lords allow me 2 days time. I'll
Call in the second week of January 2025, 26, to enable the council for the authority to come with more preparation to answer the court's question. Yes. Next.
Item 3.
Maybe the latest judgment on forfeiture. Justice Chandrachud's judgment, na? Take out that judgment. Yes.
May I please? Lord?
Yes, sir.
The petitioner lordship is a blind school. It's a blind school. Blind school.
Blind school.
School, Lord. And the management of the lordships. The school was established in the year 1991. And in the year 96, as per the prevailing 85 rules, let's kind of note down the resolution, that is 85 resolution, that was in vogue when the application was made for granting
One is establishment of.
Yes. And the first time, the management made application in the year 1996 for granting recognition and granting it.
Recognition and
Granting it. Lord, that was duly verified by the inspecting authorities, and the collector made recommendation to the government, and the government did not take any action.
Recommendation is the collector date.
That is, my lord, 39/2004. That is under Annexure 2 series. And second recommendation is 2011/2009. Second recommendation. Time and again recommendations there. And despite clear recommendation made by time, no action was taken. I approach your lordship. The lordship in the order dated in double petition number 8182/2012. By the order dated 16/5/2012, directed the authorities to dispose of the writ petition directing opposite party number 1, government, to consider and dispose of the application dated 11/8/2021 in Annexure 3 series within a period of 4 weeks.
11/8/21.
That is 11/8/21. That is the recommendation of the collector.
No, it cannot be.
Annexure 14 is the impugned order.
That is Annexure 6. That is third recommendation. Sorry, third recommendation 11/8/21. 11/8/11. Annexure 6 series page 25.
11/8
to 11. 11/8/11. That is the recommendation made by the collector to the government. And while the matter is pending, I approach your lordships. Your lordship directed to consider.
It has been rejected now.
No, that was rejected. But that was rejected, and I again challenge it. And your lordship was it, saying that is not in consonance with judgment. The judgment said, reconsider. The judgment say under 85 rules, you cannot consider under the subsequent rules. And accordingly, it is again passed and again reconsider. Then no action. File contempt. Now third time it is rejected. But that's like a lordship. See, only I want one judgment of lordships. That is the order dated 26/3/2014, passed by the Hon'Ble Court in double petition number 2275/2012. This order was passed. Then review was filed. Review was rejected. Then contempt. Then contempt. Now the order has been passed. Same order, whatever passed earlier, minutes. And I pray, lordship, kindly see. This is the judgment, minutes. With due permission, kindly, minutes, supply this copy, minutes, for lordship's consideration. Annexure 14 is impugned.
What is the reason given now?
The earlier reason, that is, let's kindly see, that was first. The earlier order was first. The same order is reiterated again, please. That is not page 52. Annexure 12.
Can I submit, my lord?
Yes.
Lordships, may kindly have a look to the prayer. So far as prayer is concerned, my lord, as to why the impugned order of the government dated 27/1/2016 under Annexure 14 shall not be quashed.
So he wants quashment of this order.
This Annexure 14 at page 65. 65, my lord, page 65. This is it. This order was passed in compliance to in contempt case number 567 of 2014 arising out of so and so. Honorable Court in wide order.
No, his short grievances.
My lord, why?
As on the date the law stood then. According to that, my application should be considered.
Considered according to giving retrospective effect. But here, my lord,
Lordship may kindly have a look to paragraph 3 of the impugned order.
In the meantime,
The Departmental Screening Committee in its meeting examined all such proposals, including that of the petitioner school, and recommended the same to the State Multidisciplinary Grantinad Committee for consideration. The State Multidisciplinary Grantinad Committee, after examining all aspects in its meeting dated
petitioner's claim.
for grantinate.
Next.
After due approval of this, it was sent to the Finance Department for concurrence.
Yeah.
In view of the above order passed
What
by
happened to concurrence?
concurrence, thereafter they must have got. Thereafter it is not there. It was
We are
sent to
receiving.
them.
We are receiving.
He is not disputing that.
No,
he
I
is
am not disputing.
Then, my lord, prayer. So there is no illegality or irregularity committed by us.
No, with effect from which date?
My lord,
18.
my lord, that impugned order is not clarifying that. They said that they have sent to the Finance Department for getting concurrence, my lord.
Yes.
And
concurrence granted now.
It is granted, he is receiving.
With effect from which date?
That the prayer is silent about.
If you read the prayer, all cases.
My lord, he is not, prayer, he is not praying for that.
No, the punishment is on that ground too.
No, it is not that. My lord, prayer is, first prayer, there is no illegality or irregularity made in the annexure 14. Second one, if the opposite party showed that is not relevant, the mandamus directing the opposite party grant according in favor of petitioner's institution release all consequential benefits in favor of the TG. It is released. It is released now.
No, 85 rules.
Grant for maintenance of inmates under 85 rules as per recommendation of the collector. My lord, that they have considered it. The committee have considered.
The order is for granting. What is the order? You read the word grant.
My lord, grant.
Which it is we are reading.
It is an aid in the shape of. It is a grant in the shape of an order. Aid. Grant in aid.
Where you were reading? You are reading the prayer.
Prayer
column. Now he said, because of your delay, I cannot be put to prejudice. I have been running the school and it is for the differently abled people. You cannot keep on the proceedings pending throughout, from sending it from one table to another, from another table to yet another table, and like this table. That is aggrieved. Why it was not granted with retrospective effect? Where is his fault? He has made in 1991 the school was established. 1996 recognition and aid was granted. Collector recommended in 39/2004, 2011, 2009, 11/8, 2011. And what is his fault? All blind people should come to your government house and strike there. At least for blind people, the government should not be blind. It should be little kind to those people, not blind to such people. Now, what is the justification? I am asking you now.
My lord.
How many litigations he has fought now?
Yes.
What is the justification for denying the benefit which otherwise he would have got?
My lord,
had his application.
Apart from this impugned order at annexure 14, there is no counter filed, so that I cannot give ex tempo any reply to your lordships.
Then I'll allow this petition.
Lordship. Looking to the eligibility criteria as mentioned in the 85 rules.
Under the 85 rules, you ought to have given it, and why there is a specific recommendation. The short grievance of the petitioner is essentially as to the effective date of granting aid. The impugned order dated 27/1/2016, having been passed under the which rules?
Under the, this is
2013 rules. 2013 rules.
2013
Resolution, all are resolution, no rules.
under 2013 resolution. First, learned counsel for the petitioner submits that the school for the blinds was established in the year 1991. It had applied for recognition and granting aid way back in the year 1996. The jurisdictional collector of the district made 3 recommendations dated 30 September 2004, 20 November 2009, and 11/8/2011. First off, despite this, in the bureaucratic way, the matter was kept pending, eventually resulting into petitioner filing WPC number 22775 of 2012, disposed of on 26/3/2014. First off, he also tells the court that a contempt petition, contempt proceedings were also initiated, and that they came to be dropped on the alleged compliance of the subject order. First, therefore, he argues, that the grant in aid has to be with the retrospective effect from which date?
With effect from 91.
How can that be 91? Your
As per the recommendation of the collector.
Your establishment itself is in 1991.
91.
You applied for recognition and aid in 1996.
39/2004 recommendation is there. 39/2004 the collector recommendation.
Well, with effect from which date? It cannot be from the date you established the institution. Then petition has to be dismissed now. It only with effect from
This is the organization.
11/8/2011. At least with effect from the latest recommendation dated 11/8/2011. First, next one. Learned AGM Mr. G appearing for the OPs vehemently opposes the petition, contending that granting aid is not a matter of right at all, and therefore, whatever grievance relating to the granting aid cannot be complained before the late court. First, he adds that it is more in the nature of gratis with no justiciable. First, he also tells the court that the grant in aid is not given as a matter of course merely on the application filed by the institution. Several procedural compliances are expected, and after examination, the decisions are taken. And therefore, by very nature of the process, delay is bound to happen. First. Lastly, he argues that the government being kind enough has accorded the grant with effect from
2018. 2018.
2018.
Yes. It is his.
Where is that order?
That was subsequent. Filed in 2016, that was subsequent.
In the year 2018, after filing of the petition. Order dated
11/3/2018.
11/3/2018.
Sorry, 14/3/2018. 14/3.
14/3/2018. 14/3/2018 during the pendency of the petition. So contending, he seeks dismissal of the petition. Others need not wait. You can go and eat your lunch. I'll complete this dictation. Having heard the learned counsel for the parties and having perused the petition papers, NPC, this court is inclined to grant indulgence in the matter as under and for the following reasons.
Number one. The establishment of the school for blinds is a laudable purpose. And that was done way back in the year 1990. First of all, in the year 1996, the institution had applied for recognition and for grant of aid as well. First of all, the jurisdictional collector, after examining all aspects of the matter, had made 3 recommendations in succession, namely, one dated 39/2004, another dated 20/11/2009, and yet another dated 11/8/2011. First of all, that being the position, there was absolutely no reason for the authorities to pass the order only in 2018, that too during the pendency of the petition. There being no reason nor right for broking enormous delay of years. First. Next paragraph. The payment submission of Mr. G that grant in aid is a matter of gratis and therefore cannot be subject matter of adjudication at the hands of the court is bit difficult to countenance. First, the grant in aid is not like a farman by the Mughals. First, it is done in a normative way, there being a plethora of orders and guidelines. Right. First, once these orders and guidelines are complied with, ordinarily, the claim for grant in aid cannot be negative. First, a strong reason needs to be assigned for negativing the claim once compliances are satisfied. First, this aspect of the matter has not been looked into by the authorities, which eventually resulted into a lot of delay to the prejudice of the petitioner institution. First one. Next one, in the above circumstances, this petition is favored. 7. Why to pass that order? That order is in your favor only.
That was said. They say that just because we have given under 2013 rules, you are not eligible. No, I am not passing that 2013. They said we have given it subsequently.
No, it is not said that. But it is said that impugned order.
A writ of certiorari issues quashing the impugned order dated
27/1/2016.
I do not know why he is asking for quashment of.
Anyway, I will quash it so that I am also of that view. It need not be quashed at all. Only thing is date to be altered. Effective date to be altered.
He is getting relief from out
under
of
this order itself.
If you shall quash it, then granting order will go.
Everything will go.
Modified.
Instead of in the above circumstance, this writ petition is favored. Although quashment of order dated 27/1/2016 is sought for in the prayer column, counsel for the petitioner has given up that prayer and tells that it should be above one more ground like this. Learned counsel for the petitioner submits that although in the writ petition inadvertently, the quashment of grant order dated 27/1/2016 has been sought for, that may not be feasible in the fitness of the things, and therefore he should be permitted to give up that prayer. First, he tells that justice of the case warrants a direction to the authorities to grant, recommend, extend the grant under
85 rules.
1985 rules. Resolution.
That is on the annexure 5.
Under resolution dated.
That is annexure. That is 31 December 85 under annexure 9, page 39.
resolution dated 31/12/1985. With the effect from, see, 11/8/2011, they have given recommendation. So from there, 6 months we will do that. Mr. G.
My lord,
If it is 11/8/2011 is the latest recommendation,
yes.
then from there we'll have 6 months for taking a decision in that way. So that will be with effect from 1/4/2012 we'll make it.
My lord, 1/4/2012, he's praying for that 85 resolution.
The 85 resolution may be,
My lord.
but it cannot be earlier to 1991 establishment.
Exactly. That is why.
What I am saying is, the recommendation 2011 is the third recommendation.
Third recommendation from that.
6 to 7 months for taking decision notional.
Yes.
If that is given, what I am doing is, with effect from 1/4/2012.
1/4/2012.
12.
It will be judicious.
That's why.
But simultaneously, my lord, I want to draw your lordship's attention. After 85, is there any resolution to that effect? 13 draw. 13 resolution.
You have granted the aid.
Granted. My lord, we have already granted aid since 2018, as is said.
What I will do is, the recommendation is made on 11/8/2011.
Yes.
Whatever government order was there during that period,
that will prevail.
As per that, you should fix.
Highly obliged.
So that you will get justice.
Yes, obliged.
A writ of mandamus issues to accept recommendation dated, Deputy Collector's recommendation dated 11/8/2011 at Annexure
6 series.
At Annexure 6 series. No, it cannot be 6 series, only one. There are 3 different this one. Last one is dated.
You know, kindly see page 25. That series because with the recommendation of the inspecting agency, that is there. Recommendation along with the inspection agency reports. You know, kindly see page 25.
11/8/2011.
11/8. That is the recommendation along with the letters.
At Annexure
6 series.
6. 11/8/2006. Keeping in view the extant government resolution then existing. And, it has to be with retrospective effect from the date of the then existing recommendation itself. First, compliance to be done within a period of 3 months.
Sometimes 13 resolution will not apply.
Sometimes
2013 I am getting.
11/8/2011, which
all
was
right. That is the 85 resolution.
That will be applicable.
My lord, sometimes more time may be given so that.
4 months. 4 months will do.
With the permission of the Honorable Court, my lord.
Yes, sir.
I am on my way to father-in-law's house for a specific issue, urgent issue. My item, your lordship has paid to consider, I mentioned item 5 and 40. It is in the list. May I pray not today or tomorrow, day after tomorrow? Urgent matter, but I am in a difficulty. My father.
No, that I understand. What is the urgency for these matters?
Urgency is that 2012 matter, he is not getting his salary and other thing. Any date next week or Monday, next Monday. Monday, 5 and 40.
5 and
40.
40.
What's up like?
Counsel for the university inadvertently I have not served. Today I am serving the copy. Let it come after the in the meantime they will take instruction.
I am on behalf of Orissa University of Technology and Research Manager.
After vacation.
After vacation.
Vacation and the rest of what?
Which really thankfully. Gratefully.
Yeah.
Vice.
List item 4.
I am appearing on behalf of the entrepreneur opposite party. My petition has already been allowed.
Your impediment is allowed. And you have been impeded.
I have been made as opposite
party.
by virtue of the order of the court. Petitioner is not there. It is relating to rejection of the petition. The rejection of the petition for rejection of union by the fire services.
Firemen and Havildar Association. Havildar Association.
Earlier it was the
Anyway, he is not here. Counsel for the petitioner is absent in this old matter. First, call in the second week of January to enable him to come and argue. Yes.
Item 5 has been urgent. Item 6.
Item 6, my unnecessary SP Mr. has to argue this matter. He is suffering from fire anxiety, Your Lordship.
Arguing from his seats. First round. Therefore, call this matter in the third week of January.
Item 7.
Sir, on behalf of Mr. Guru, the matter to be taken up by tomorrow.
Why not today? Today it is there, na?
Yes, sir.
He
is not currently present.
Who?
The petitioner.
Call this matter in the second week of January 2026. At the request of.
Item 8.
Yeah.
Whereas the case, the petitioners were appointed as education volunteer.
Education volunteers.
2003. Thereafter, in the meantime, scheme abolished. So government decided to react. Government decided a resolution to rehabilitate the petitioner to the post of Ganasika. Thereafter, matter was decided. This was report in the case of matter was this petition CORAM put on application.
Yeah.
Matter was decided in the common judgment in the case of Rosmir Kavatra versus State of Odisha. These petitions were also there.
Similar matters.
Mr. Your Lordship. Thereafter, Your Lordship, another second round, Your Lordship, page 38, second round written. RSR 11. Second round, thereafter also the page 38.
Recording in progress.
This matter. Page 38. Now again matter has been rejected on the same ground.
On what ground it has been
ground petition was appointed in the alternative innovative education centers. Therefore, their claim cannot be considered in view of the government resolution.
Similar matters, how they are.
So, the petitions were initially appointed as.
You said how other judges have treated similar matters.
Your Lordship, similar in the meantime, taking into note of that case. One matter has been decided, Your Lordship has decided.
I have decided.
Yes, sir. Taking
that
to note
wherever vacancies are available, they should be accommodated.
Taking to note that
there is no vacancy. It is not
no,
vacancy.
wherever vacancy is available. Vacancies are bound to occur because of death, resignation,
Lordship,
retirement.
That is a normal law of service law.
Correct.
But here, he was appointed under a particular scheme.
What scheme? Criminal matter is covered by my judgment.
My Lordship, because there are two schemes we are governing. Well, this is education AIE. AIE scheme.
AIE means?
AIE guideline.
Education guarantee scheme. This is AIE means I'm forgetting the full form. My Lord, the persons those who were engaged as education volunteers under EGS centers where after disengagement they will be engaged as Ganesh Shikshakas. But so far as this AIE centers, those who are coming, they are not coming under.
What is their qualification?
Then.
No,
you will also kindly see the answer.
I'm asking a question.
They are not coming. That is that they are different.
Whether qualifications differ?
Qualifications
do not differ. Functions do not differ.
Well, they were all trained. These people are. They were also trained.
They were also trained.
These people are not.
You are not trained.
Yes, sir. Similar situation.
Show that where you have stated.
You will also kindly see
people.
Unless you will also 34. You will see 34.
Page 34.
Yes, sir. Page 34, page 35. You will also see the government. Their decision.
What is 34, brother?
You will also 34 government letter, collector of chairperson.
Where is that training
Annexure 7, your lordship, my first your lordship, kindly available. 7. The resolution dated 16/2/2008 for the purpose of universalization of the elementary education, education guarantee scheme, that is EGS, an integral part of Sarva Shiksha Abhiyan, was operationalized in the Odisha from 2001 to, with due to upgradation of EGS centers to regular schools. For various reasons, the education volunteers engaged in such EGS centers have been disengaged and would be facing disengagement in the above process. Government, after careful consideration on the above problems, the education volunteers under the education guarantee scheme decided to rehabilitate the education in the education centers who have been disengaged and facing disengagement under the education guarantee scheme on the following manner. It is only the disengaged education volunteers will be rehabilitated. Correct. Not these people are not there in the EGS centers. They are AIE.
I have understood. They may not fit into this scheme. But you all have a similar scheme. These are not statutory schemes. They are all arising under executive power.
My lord, these are the schemes to rehabilitate the education volunteers. Gana Shiksha.
Yes.
These people are not.
They are not Gana Shikshaks.
They are not Gana Shiksha.
Correct.
They are praying for to be rehabilitated as Gana Shiksha.
No, as Gana Shikshaks they may not be. You are engaged as an education volunteer.
Yes, volunteer.
At least education volunteers equivalent.
They cannot. No, they cannot. Because they were not permitted. That education volunteer scheme is closed. Scheme is closed.
Of this
Lordship, Annexure 53, page 14, one order of the government, the presentation, it is there. This petitioner who was present in person has submitted that so and so, so and so, so and so. In presence of all, this matter was decided. The petitioner so and so is a disengaged education volunteer.
Why can't you see this judgment for a moment, Mr. G? Just look into, face this judgment. This judgment covers the very identity. Give that.
7.3.
First paragraph. Where is page number 2 of this judgment?
My lord. Out of page nahi hai there.
Take out page number 2 of the judgment from our records. Identical issue has been decided. If you are aggrieved, you file appeal against that. That case related to education volunteers only. Maybe that your friend has not furnished that page number 2. I will furnish it now to you. Because I remember being the author of the judgment. I remember. Yes. You, Mr. G, also one copy.
That is what. Pairing is given. This is the first page, second page. First page is there.
First page is there. Page number 2. Page number of na. Get full judgment. You have come without second page. All these petitioners were before the court earlier?
Yes, ma'am.
They were there.
Yes. Pattern
By single petition or separate petitions?
suppose pattern program all right. Similar. No, single, all are single.
Technical cases there, sir. It's not obvious. Yes, but would you share that copy to Mr. G? Just look into this page 2. Identical. Pause.
My lord, one second.
Let me see the order, kind of order I have made.
Instances, both there is success, it's actually requesting the impugner. Observe the petitioner in any scheme project within a, let him pass this.
Yes.
No problem.
Therefore, you have nothing to lose. You let. The subject matter of all these petitions is substantially similar to one more copy have. Similar to the one treated by this court in WPC 16773 of 2016, connected with WPC 16774 of 2016 between Jugal Charan Nayak versus State of Odisha and others, heard and disposed of by this court. White judgment dated 13/8/2025. First off. At paragraphs 7.1 to 7.6, this court has furnished the reasons as to why some relief has been granted to the litigants in the said petitions. First one, the same read as an. Next paragraph. Counsel for the petitioner points out the operative portion of the said judgment, which reads as under. Below that. He further submits that like cases should be treated alike, and therefore whatever relief that has been accorded to the litigants in the cognate petitions needs to be extended to these clients on the principle of parity. First off, there is force in this submission. Though learned AGA Mr. G tried to differentiate the facts of the issue at hand from the cognate petitions, no difference is demonstrated as such. First off, whatever other differences are not relevant to the adjudication of the case. Such differences always being there in every case. First of all, in the above circumstances, succeed in part the impugned orders or a writ of certiorari issues quashing the impugned orders. You have to put all dates using it, all those petitions. Okay? Give that dates, just dates. Right. So a writ of mandamus issues to the OBs to absorb petitioners in any new scheme or project within 8 weeks without driving them to one more round of legal, provided that such schemes or projects are in obtainment. Please go on.
Item 9, quickly list item 9.
Lordship, in the sub-item 2, our power has been, the file has been transferred and our power has maybe deleted.
Who appears?
Prafulla Kumar Rath.
You do not appear.
Lordship, file has been transferred.
It is taken back by the
is council.
Some other,
which lawyer is engaged?
I have been engaged by the petitioner of the second case. I will file my Bakalatnama only one date maybe.
In the connected matter, 3 points of appeal for the petitioner in the state of.
I'm the petitioner in the second case.
Shri so and so, who is permitted to rely on the case. Call in the 3rd week of January 2025 as requested. Okay.
Item 10.
Last order, 11/11/2025.
Yes.
Directed to the James.
Grab that mic.
Your Lordship, kindly see the last order dated 11/11/2025. Your Lordship is directed to produce a medical report from the petition
case about. Last order?
Yes, please.
Very good.
Petition was referred to the James for a medical exemption. And accordingly, he has appeared and a medical test was conducted. So, awaiting the report.
Why report is?
My lord's noting says report is
sent. Any report has been received?
Will sealed cover. My lord's noting.
AG office.
Again, amended.
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 That
In shade cover.
in silk code, any silk code is that? I would stand. Where is the report? Only later we are seeing. Where is the medical report? Take out that cover, open, and all of it there. No. It must be there now. When they said we have sent, it must be. Check what. So where is the medical disability? 0.0, this one, the medical disability.
Your Lordship, kindly visualize. I have given the same AIMS report, my Lord, under Annex 7. The state board gave a medical certificate. On the basis of that, I was selected. And College of Barampur. They have given 20%. Thereafter, the district board sent to the district board. They have given 50%.
No, now they are saying 0%. That means your client is very well.
Very
Why they will give false report?
No, I am not. I am not. I have whatever facts available and materials available. I am submitting before Lordship. SC Medical College is also given the 70% and 60%. AIMS also given the 60% and 75%.
Now, because we did not go by that, we sent you to AIMS here.
Yes, ma'am.
AIMS says you are absolutely all right. Call our doctor, court physicians. The board has given the report in such a way that I have to do masters in ophthalmology to understand what it is.
My lords, in fact, the disability certificate produced by the petitioner shows it is temporary in nature. So it varies.
Correct. Yes, tell him it is in connection with the case, not with the judge. We should not be under the impression that because I am his patient also, we should not think that he is urgently caught. He is part of the connection with the case. Another software. Glance that I am not very sure that you will be able to make out more than what I have made out. This is for medical course or employment? Yes, employment. PWS category under the
physically handicapped.
Physically handicapped category. Now you are no longer physically handicapped, as per the report of the.
With the relief.
No, that's not. That makes no sense. Is that physical handicapped? That which is that PWD Act. Persons with disabilities. New act has come. 2016 act has come. In 2016. Go to permanent disability. Any definition? Definition of disability.
My lords, here the resolution says somebody who will avail the facility, avail the quota of physically handicapped, he has to.
Dr. Sir, please come. We have a small issue which will help us now. Kindly explain this report to court and to the bar also. That's a case relating to physical disability, audio disability. Definition of disability, what is that? Yes, ocular. No, may not fall into it. It is like Stephen Hawking, etc. They were there, that kind of it, not these two. What is the report, Dr. Sir? Is a normal report says normal or abnormal?
In the right here, there is normal, there is sensitivity. Right, there is normal. The left here, there is minimal to mild conductive blindness.
Means?
So actually, there is no degree. This is the prediction. Person, if not cannot here, that's normal. Like till 2025, like suppose normal is specified. That is nearly about 5 to 10 decibel. This person cannot hear, so cannot do. It's not normal. Not having hearing loss. If 20 to 25 to take it as normal. But this person cannot hear to 30 decibel.
Means 1 year. The other ear is normal.
Right ear is normal.
Other ear is normal.
Right one is normal. Left one has some right to moderate.
Even that also works. The left ear also. Whether the function hearing, what is the extent of audibility?
This is mild to moderate hearing loss only.
Mild to moderate.
I mean, sometimes speaking.
If you whisper, he cannot. If you bit loudly, if you say, he will be able to. Then where is the disability? Better. Petition prayer reads as an first. There were multiple reports. Thank you so much. Thanks. Kindly give that I will put a few pleasant words about you. Your designation, I think. About audibility, disability in terms of audibility. First, this court-wide order dated, where is that? Give that right. And so, had said as in terms of that, the medical test was conducted by James Oneshwar and report dated 6/12/2025. No, 4/12/2020. Medical report dated 4/12/2025. Has been issued. Since the contents of the report were not easily intelligible, the assistance of courts, are you courts physician? Medical officer, the assistance of medical officer, courts medical officer, Dr. So-and-so was solicited. First one. Doctor says that it is not a case of physical disability as has been projected in the petition. First one. The report is of an expert which is entitled to due weightage under Section 45 of the Indian Evidence Act 1872. Something like that.
Sakhya Niyam.
Sakhya Adhiniyam. The new one has come now. So corresponding section has to be just look into that and reframe that. First one. The entire petition is structured on the premise of physical disability, which is not demonstrated by the latest report of the AIMS. First one. There is no reason to doubt the report either. First one. In the above circumstances, petition being devoid of merit is liable to be and accordingly rejected. Yes.
May I submit a copy maybe? Medical
Copy
report.
of the report.
Yes.
Yes, copy of the report. Just check that copy with them. Xerox copy. You will call it. Next. Thank you so much.
Item 11.
May I please, Lord?
Yeah.
The petition is aggrieved by the order under Annexure 7 at page 42, 26/3/2018, by which dismissing the petitioner along with 165 other Shiksha Sahayaks. Facts are like this, my lord. Facts are like this, man. In 2003, advertisement was issued for appointment of a Shiksha Sahayak in 2003.
2003, kindly give the date.
2003.
26/5.
That is 25/3/2003.
25.
I have also filed the date chart that is available with record.
Date chart you have given?
Earlier I had given in the other
Do
batch.
you have the date chart? 25/3/2003 is advertisement.
There, it was mentioned that it was the appointment for a Swechasevi Shikha Sahak, that is from Matrix City and a BAPD. And there it was held that if the scheduled caste and the scheduled tribe candidates are not available, then on-trend SC/ST candidate can be appointed. So process of selection was continued, and there also the petitioner applied, and
There is STs.
yes, ST. This is SC.
Yes,
SC man. What happened, my lord? There are 119 posts for Rairangpur district in Mayurbhanj district, that is Rairangpur educational district. Then there are 68 posts to be filled up from the SC category on the basis of 16.25%.
16.25%.
That as per the fixed by the government, that is not disputed, my lord. So 60 out of 68, only 7% of SC candidate were appointment as a trained candidate were appointed. The petitioner admittedly on trained, but his case though considered and his name was also placed in the selection list, but he was not appointed. What happened in the meantime? 15,600 something was and also became vacant. So government added those posts along with this. And accordingly, process of selection appointment were issued. That was challenged in the High Court. High Court says no, the rest of the 15,600 posts, it should be filled up by way of a new advertisement. Lord, you cannot add it there. That is also confirmed by Honorable Appeals Court. In the meantime, the petitioner was appointed under the on-trend. But he has not participated selection in second advertisement. From first advertisement, as because out of 68 posts, 7 were only SC candidate were appointed, so petitioner was appointed out of that. That is my submission, my lord.
First advertisement were how many vacancies?
That was 419.
419 vacancies.
Yes, my lord. That is admitted fact, man. So out of 419, so only 7 were appointed. That is out of
5% will become how much?
That is 68. I have given in my additional affidavit available in, I have given the calculation sheet. That is at page 165. So then, in view of the latest circular, I applied that after 3 years I should be declared as a junior teacher. After 3 years, I will be treated as a teacher. So I filed the case here, this Honorable Court, one and after one case, and this Honorable Director to consider the case. Lastly, Annexure 7 was issued.
Rejecting the case.
Rejecting case in view of this Honorable High Court judgment, that 15,600 posts that were added. That's why my case was rejected. And my appointment was rejected without any notice or anything.
What you say is the other appointment is nothing to do with your case at all.
Yes, my lord. That is because I was a candidate for the first election and first advertisement.
First selection of
that advertisement was 22/3/2003.
For 5,000 vacancies.
Well, Lordship, while hearing other cases, there are 166% failed the retrenchment. That means disengaged. So some cases were filed in other bench also. So this Honorable Court and that was that. So Lordship, kindly see 13/11/2023 order.
13/11/23.
This Honorable Court directed that the case will be disposed of after disposal in other coordinate bench.
So that related to that 15,000 order.
That is not 15,000. That is also in
this case. What happened?
56, they were written, then they were press advertisement issued and they were appointed.
WPC 5398 of 2018. What happened to that case? The order of brother judge.
No, that order I am showing, madam. That pursuant to that order, then your lordship, first the case was dismissed, thereafter review application was filed, and in review it was allowed.
Yes. In review, what happened?
Review was allowed that the case was on-trend SC woman, but our case is a SC man. And the order, your lordship, kindly see.
No, that makes no. What is the order in this?
There is illegal and
again remitted back for reconsideration.
Your lordship, kindly see.
Collector.
Asked to the collector.
And the direction was issued to reinstate him.
Reinstate that page 19. At page 19 of the.
This is only in October 25.
Correct.
That is at IV and 5. IV, the matter is remitted to collector comes your Jilla decision within 8 weeks on the following specific issue. Whether petition engagement by the order number such and was against one of the 16 SC women post, that is in within 68 of the post. Notified under such as advertisement, whether the 16 posts were merged into the 15,682 posts.
Your disengagement order is dated what?
That is order dated. That is 26/3/2018.
That's identical.
Yeah, identical. That 23 this year is also a party.
Only difference is you are untrained.
All are untrained. She was also
untrained.
Yes.
In the
meantime, we have a
path.
In the meantime, then that strengthens his case.
In the meantime, that is the also here in our.
No, any appeal is filed against this judgment.
I have given a copy of to my.
Then it's 100% covering. 100%.
And the person who was upon the case is there, they are also party to the disengagement. She was a party also.
Was also a party.
Same party. That is the annexure 7. She was also, her name appeared.
Subsequent
No, Mr. G.
My lord, here there was
100% similar matter. Plus addition is he is a trained candidate.
I have.
See, now 419 vacancies.
My lord, at that point,
you appointed only 7.
At that point of time, my lord, it was meant for trained. But subsequent
No.
My lord,
trained candidates are not available.
My lord,
Then untrained also. There is such a clause I have read that.
My lord, at that letter stage, such clause was inserted probably.
No. That is
advertisement itself. Advertisement dated 22/3/2003.
Yes.
Kindly see that advertisement.
And next page 24 in respect of SC/ST category. Page 24.
24.
Yes.
That was the election.
In respect of SC/ST.
After the trained teachers, the trained persons are engaged, the remaining will be filled up by untrained.
Even otherwise remaining with are there.
Yes.
You have appointed only 7 as against 68 available.
Yes.
And no reasons are given. Even otherwise also, how can I differ from the view of my brother? No. Learned counsel for the petitioner, drawing attention of the court to the coordinate bench decision in review WPET number 31 of 2025. Versus State of Odisha. Decided
my lordship, bear with me for a moment.
Yes.
This is meant for lordship annexure 1. Engagement of para teachers against the vacancies of assistant teachers in primary school. Two types of.
No, that time it was said as a Sarva Shiksha Abhijan, SSA. Thereafter in 2008 it became Shiksha Sahayak.
No.
And that was similar because they are.
But your lordship, in one day, 2 notifications were there. One is for para teacher, Sarva Shiksha, Swachhasevi Shiksha Sahayak, para teacher. Another is for Swachhasevi Shiksha Sahayaks. Here it was referring to para teachers. But the vacancies, what your lordship is indicating, it is meant for Swachhasevi Shiksha Sahayaks.
No, that is the case. Review case is that one only. Even that is discussed.
Annexure 1.
No, all right. Now see the judgment in review. They mention the same thing. In the very first paragraph it is mentioned. judgment. Have shared the copy of the judgment.
Yes.
First paragraph.
And that is, I will clarify my young brother. Kindly see para annexure 4, it has been mentioned earlier, Sochasevi Sikhayak, including the existing one, will be called as Sikha Sahib. Annexure 4. Earlier it was Sochasevi Sikha Sahib. There it was not so that what is the procedure to become junior teacher, and also thereafter what will be the regular. In 2008, 10/1/2008, annexure 4. Kindly see. 2008, annexure 4. Para 3. That engagement of new Shiksha Sahayak will be made by Jila Parishad. Prior to 2, the henceforth all Sochasevi Shiksha Sahayak, including the existing one and the new recruits, shall be called as Shiksha Sahayak. That is at page 32.
You were disengaged on which day?
That is on 26/3/2018. Also, that review petition, she was also one party that the disengagement. Her serial number was, that is at 89.
Submits it in so and so. Decided on 17/10/2025. Submit that the case of petitioner is sent and covered by the said judgment, and therefore the relief granted to litigants in the said petition needs to be extended to his client as well. First, next paragraph. At the paragraph 24 of the cognate judgment, the following relief has been granted to the litigant in the said petition. First. Next paragraph. Despite the vehement submission, Mr. Lenka, learned DG, is not in a position to differentiate the fact matrix of this case from that of the cognate decision. First off, even the date of disengagement is also same. First off, next one. In the above circumstances, this petition succeeds. A writ of certiorari issues quashing the impugned order dated
26/3/2018.
26/3/2018, as has been done in the cognate petition. First off, the relief granted to the cognate litigant is extended to petitioner herein. Mutatis
Others are, all are same. All are same. All
are same.
Yes, madam.
All means how many?
32.
30, please.
33.
Within list item 12.
Next.
Item 12.
12 में pass over.
No Passover, all in the third week of January. Yes.
Notice item 13.
13, interim order to continue. Interim order is there. Then in the second week of February, interim order to continue till
13 में kindly taken after holidays.
After the vacation, as requested.
Item 14.
14.
May have did, my lord. Here, my lord, the petitioner. Here, my lord, the petitioners are the retired employees of the Cuttack Central Cooperative.
Retired employees of Cooperative Bank.
Yes, my lord. And they are aggrieved by the unwarranted interference of the registrar in grant with the decision of
retired employees.
Retired. At the time of filing of the writ petition, they were serving. So
they were in service and thereafter they retired.
Yeah, in the pendency they retired, my lord.
No, what remains?
That what has happened is that adopting the state policy to extend the benefit of 6 to give that benefit retrospectively as has been adopted by the state government. The difficulty was at that relevant point of time. At that moment, the bank was suffering losses. Therefore, decision was taken to give it prospectively. After the bank has started incurring profits, the bank took a decision by the committee of the meeting to give them retrospectively with effect from 1/1/2006, my lord. The
1/1/2006,
my lord. The 6th pay. And so far as the 7th pay is concerned, from 1/1/2006.
Benefit of 7th pay commission. 6th pay commission and 7th pay commission.
As per the rule, my lord, Rule 26 of the
cooperative rule
of the cooperative staff service rules, my lord, it says that if the bank fulfills the criteria which has been mentioned therein, then they do not require the permission of the registrar.
Read that too.
Yes, that is also there, my lord, enclosed in my additional affidavit. First state petition, additional affidavit D. That rule has been prepared in excess of the power given under the Act, that is Section 33A(2), my lord.
That gives power to make the rules.
Of the registrar to make the rules relating to appointment, conditions of service, and payment of service rules, my lord. Rule 26 states that this pay,
which section gives power?
Section 33A(2), my lord. Of the Odisha
capital A.
Capital A 2 bracket numeric 2.
Of Odisha Cooperative Societies Act.
Yes, my lord.
Yeah. 1962. 1962 Act.
Rule 33A, qualifications, etc. of employees of societies. Subsection 1, the registrar shall fix the number and designation of the employees to be employed by the cooperative societies. And the relevant one is make rules regulating the qualification, remuneration, allowances, and other conditions of services of such employees. Thereafter, sub-rule 2.
Pay also includes condition of
services.
Yes.
Notwithstanding anything contained in subsection 1, the registrar, in consultation with the National Bank, may issue guidelines in the matter of personnel policy, staffing pattern, recruitment and fixation, and revision of pay and allowances of the employees of the cooperative credit society, keeping in view the
power is given to him, notwithstanding whatever rules he will do. He can consult the other body. Which is that body?
That is the National Bank, my lord. National Bank.
National Bank.
In this case, the NABARD is the
NABARD.
NABARD is the
in consultation with NABARD, he will accept should be the emoluments, what should be the service conditions. He can do that.
And in terms of the said section, my lord, the power, the Central Cooperative Bank Staff Service Rules 2011 was created, my lord. Itself, it is there in the first phase of the. I've given an additional affidavit, my lord. That is at flag D, my lord.
No, you are saying, as I understand, matter relates to denial of prospective benefit of 6th and 7th pay commission.
Yes, ma'am.
Your first contention is pay revision is a condition of service. So that will be governed by the rules made under section 33A(2) of the Act. And only in a particular contingency, it requires approval of the cooperative officer.
If they
or somebody.
Yes, ma'am. If they don't fulfill the criteria, then only the registrar, they have to take consideration.
So criteria are fulfilled. The question of taking permission will not arise at all.
Will not arise at all.
In this criteria is fulfilled.
Yes, my lord.
What are the criteria?
The criteria are Rule 26, my lord. I've enclosed in my additional affidavit D.
Now, is it your case that the criteria are not fulfilled?
The bank has its own advocate.
The registrar has not filed.
You appeal for the bank.
Number 4,
You support or you oppose the petition?
In fact, Your Lordship, the condition right now is that, Your Lordship, an order has been passed by this Honorable Court wherein the financial power of the management committee has been transferred to the administrator. The collector of that district has been appointed as the administrator.
With effect from which date?
Your Lordship, I will supply the copy from 7/3/2025.
7/3/2025. But case related to
separate case, that was with regard to the suspension of the management committee. That was challenged before this Honorable Court. As an interim, the Honorable Court has directed that the financial power shall be transferred to the administrator.
And now that is before that, what all happened? This happened only in March 25.
Yes, Your Lordship.
But this case is of 2021.
Yes, Your Lord.
2021, and prior to that, they have taken the decision to grant them the benefit.
In fact, Your Lordship, if the decision has been made, Your Lordship, I don't have any issue with that. The only problem is that, Your Lordship, with regard to seventh pay, there are two cases, Your Lordship, the sixth pay and the seventh pay.
Correct.
With regard to the seventh pay, if Your Lordship looks at my counter which I have filed.
See, sixth pay says 1/1/2006 effective date.
Yes, Your Lord.
Correct.
Yes.
Seventh pay is 1/1/2006.
Yes.
His question is, when all criteria are satisfied, where is the scope for intervention of the registrar?
In fact, Your Lordship, since we don't have any objection with regard to the payment, because at that stage, Your Lordship, one of the criteria was with regard to the financial condition of the bank, whether they're making profit or not, which they did not make. Subsequently, they started making profit. Hence, the criteria is now fulfilled. Yes, but Your Lordship, since during that time, the registrar had already rejected the presentation, which is under challenge in this writ petition. Hence, no decision was taken with regard to the payment or not, Your Lordship. But with regard to the seventh pay, if Your Lordship looks at my counter affidavit, Lordship, counter affidavit, I have annexed annexure A4. That is a letter from the registrar. The registrar has issued it to all the secretaries, in fact, the bank also, stating that if the parties fulfill the condition, then we may take a decision with regard to the payment, Your Lordship. If the
Why registrar says all that?
Yes, sir.
Restriction is only when the prescribed criteria are not satisfied.
Yes, sir.
He should see whether the criteria are prescribed, which are prescribed are satisfied or not.
Yes, sir.
Rest of the things, very big scope for intervention.
Your Lordship, whether they have fulfilled the criteria.
Cooperative right to form a cooperative society is a fundamental right.
Yes, Lord.
Therefore, it's a fundamental right and it is subject to reasonable restriction is true.
Yes, Lord.
It is not an ordinary right. Is it not? Constitution is amended. Which date? Right to form cooperative society.
73rd or 70 something an amendment.
So it was before the case arose.
Yes, sir. In fact, Your Lordship, the issue right now is, Your Lordship.
Just I'll ascertain. With effect from which year? More than 10 years. I mean, it took place when I was at the bar. 2011. 2011.
Yes.
97th Amendment. With effect from 2011, with effect from which date? You also have the same disease of the bar now. You are not giving the date at all. Yes, the government has to justify what the registrar will say.
Then
I have to allow it. Their representation was for what?
The representation was with regard to allowing the same, Your Lordship, which is the issue here.
Benefit with effect from 1/1/2006 and 1/1/2016.
Yes, yes, ma'am.
That is rejected.
Yes, yes.
Take down.
And
Rejected, wide order dated
Rejected by order dated 10/8/2021. The 6th bill.
10/8/21.
10/8.
Yes.
10th August 2021.
Annexure 16. That is due to financial condition of the bank. But that
No, that will go away because the bank started making profits. So that with effect from 1/1/2006, you recommended with that only.
Yes, sir. Subsequently, it was recommended, but it was rejected. The representation was rejected. That is why we could not
Unsustainable.
proceed.
Right now. How many petitioners?
Presently, the union.
Union.
Yes, ma'am.
No petitioner is made a party.
Petitioner are there. 4 petitioners.
4 petitioners out have rejected your.
No, madam. 4 petitioners.
Yes. First petitioner is union.
The union represented by the general secretary, who is also the member, employee of the Nayagarh Cooperative Bank.
Then other petitioners are
also employees, my lord.
They are employees.
They are employees, so also the part of the union.
They are also part of the union.
Yes, I've given the nomenclature also. The cost title.
It's a trade union or association?
As registered, not trade union.
Not a trade union. Trade union set 1926.
No,
not. That employees association.
Employees association.
Registered association.
Yes, madam. Registered.
Under the 1902 Act. 1911 Act. First petitioner is an association of employees of the respondent cooperative bank, OP Cooperative. And other petitioners happen to be its members. First, they are waving before the writ court against the order dated 10/8/2021 made by OP number?
OP number 2, my lord.
Who is he?
Registrar of the Cooperative Society.
OP number 2, who happens to be the Registrar of Cooperative Societies, whereby their representation dated?
Representation dated. Annexure 15, my lord.
Asking the date. Understand English. So and so has been rejected. First, in the subject representation, the petitioners who are now retired, comma, who are since retired, comma, had requested in effect for the extension of revision of states pursuant to 6th pay committee recommendation with effect from 1/1/2006 and 7th pay committee recommendation with effect from 1/1/2016. First. Next topic. Learned counsel for the petitioner vehemently argues that right to cooperative society itself being a fundamental right by virtue of 97th Amendment to the Constitution with effect from 15 to 2012, comma, the interference of the state authorities in the administration of the cooperative society is unjustified. 7. Even otherwise, according to him, there being rules promulgated under section 33 capital A bracket of Odisha Cooperative Societies Act 1962, comma, the registrar could not have arrogated to himself the power in the absence of non-satisfaction of the criteria mentioned in the rules themselves. First of all, learned panel counsel appearing for the cooperative bank, OP4 bank, submits that his client, as a matter of policy, had extended the revision of pay scales, the subject pay scales, with the respective dates, which are bit prospective, regard being had to the profit earning during the relevant period. First off, however, the registrar having not agreed to the proposal, now the ball is in the court of the registrar himself. First off, learned AGA, Mr. Lenka, appearing for the answering official OPs, opposes the petition, contending that the pay revision is one of the service conditions of the cooperative bank, and therefore supervisory powers do avail to the registrar in the best interest of the very society itself, which deals with the public money. First, so contending, he seeks dismissal of the writ petition. Next one.
Matter. It was a direction from this honorable court to the registrar to take into consideration the representation filed by them.
Correct. We have crossed that point now. Having heard learned counsel for the listen, sit down. Having heard a learned counsel appearing for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter as under and for the following reasons. First off, the service conditions of the employees of the cooperative are regulated by, which are the rules? Give the name of the rules.
Rules 26. That is, I've included that rules in my additional affidavit. The rule is
the Odisha Cooperative Societies.
The Central Cooperative Bank Staff Service Rules 2011.
Which page you are seeing? Are we in the same book or different book?
Different.
Yes,
That's a
just
different book.
right. So give that book 1 minute. I'll just look it and give back to you.
Yes, ma'am.
I will not retain your book.
No.
Governed by the Central Cooperative Bank Staff Service Rules 2011 that are promulgated by the registrar.
Yes, my lord.
Registrar of Cooperative Societies under section 33 capital A bracket into brackets 2 of Odisha Cooperative Societies Act 1962. 62.
That is there at
and answer.
Screen, my lord.
In this book. Yeah.
And it's the extract of the relevant pages, ma'am.
Rule 26.
Yes, my lord. The second flag, yellow flag. That is also enclosed in the additional affidavit.
Rule 26 reads as under. Can I return your book after 1 or 2 days?
Yes, ma'am.
Page number 35 of this book. I just make it there. That's vanishing. No, sir, that is what I am saying. Not a vanishing note. Only A, 2A will be, clause A will be relevant.
Rule 26.
Correct. Rule 26,
Yes, sir.
clause A will be relevant. That excess shall not be 2% of the working fund.
And
Only that will be relevant.
A and B.
A and B also.
The bold ones are the exceptions, my lord.
And apart from that, yes, A and B are right.
The bold one has the
26, A and B.
and C also.
Bank should be working on net profit of so and so.
Yes, ma'am.
A, B, C, all three.
Yes, madam. And the bottom two bullets points are the exceptions. Under what circumstances the register will come into
the proviso and other.
Yes, ma'am.
As it is. The text of the above rule shows that the essential power of prescribing the pay scales and granting pay revision belongs to the managing committee of the bank itself, subject to the riders mentioned in clauses A, B, and C. First stop. Of course, the proviso, the first proviso to Rule 26 gives some leverage for the interference of the cooperative authorities only in the specified circumstance therein. First stop. Admittedly, the bank which was undergoing losses earlier came to good financial position later, and therefore the policy decision was taken by the managing committee of the bank to extend the benefit of 6th pay and 7th pay revision committees respectively with effect from 1/1/2006 and 1/1/2016. First stop. When the bank's financial position was pretty good, absolutely no justification whatsoever for the registrar of cooperative societies to intervene in the matter, as rightly submitted by the net counsel for the petitioner. Next paragraph. There is force in the submission of net counsel for the petitioner that the right to form a cooperative society will lose its pith and substance if right to manage affairs of such society is unjustifiably curtailed by the departmental authorities. First, it is the managing committee which knows what pay scale should be given and what pay revision should be extended to its employees. Of course, this is subject to regulatory provisions promulgated in Rule 26, which is reproduced. First, when the bank was earning profits, sharing a part of that with the employees is consistent with the directive principles of state policy under Article 43, as broadly interpreted by the apex court in the case of within that judgment. So and so. First, in the above circumstances, Two petitions or one petition?
Two petitions. One is for 6th pay, the second one is for 7th pay.
These petitions succeed. First, a writ of certiorari issues quashing the impugned orders dated, both dated 23?
No, my lord.
Dated 26/3/2018 and
29/6/2021.
29/6/2021. Above also that date. Only one date we have put.
The first one is 10/8/2021.
Huh?
The first one is 10th August 2021.
10th August?
2021. Annexes 60.
You are right. 10th August 2021. And the second one is
29th June 2021.
29/6/2021. First one. A writ of mandamus issues to the respondent bank to sanction and grant the benefit of 6th, 7th pay committee recommendations respectively with effect from 1/1/2006 and 1/1/2016 within a period of 3 months. Within a period of 3 months. First, in the peculiar circumstances of the case, no interest nor cost is awarded.
Last case, the representation dated 24/10/2019.
Representation is 24/10/2018.
In the second case, the entire writ petition was directed to be treated as representation.
In the second case, there is no representation.
The direction was to treat the petition as a representation.
In the earlier round of litigation, you were before this court in the earlier round of litigation.
Yes,
one sentence you have to mention. It is noticeable that petitioners were before this court earlier in WP number.
WP number, my lord.
First case.
3/8, it's my lord, sorry. 8/3 of 2020. Disposed of on 17/12/2020.
Disposed of on 17/12/2020, wherein a direction was given for considering the subject representation of the petitioners.
Dated 24/10/2019.
24/10/2019.
The next one
in the next
that representation has been wrongly considered, and thus there is an error apparent on the face of the record, warranting interference on this court. Make it another.
And the second one is WPC number 33124 of 2020. Second petition.
WPC
33124 of 2020. Disposed of on 16.
Two petitions were filed earlier.
Yes, my lord. Here also.
One set by in respect of 2006 and another is for 2016.
Yes, ma'am.
That is petition also. Tell that.
33124 of 2020.
Decided on
16th December 2020.
Same day.
Same.
Both are decided same day.
Yes, ma'am.
Separate orders or same common order?
Separate orders. This one is 16th, the earlier one is 17th.
17/12.
17. One is 17/12. It is there in the certificate. It is the structure it there. Oh, bless my lord.
All right.
Total list item 15.
Into 15 minutes, there is an amendment application which is there at it's flag C.
Amendment. What you want to amend?
It's here, minutes after the filing of the counter affidavit. And in the writ petition that a particular authority is not empowered to pass such an order.
What is that order?
That is an order of cancellation of a renewal application for registration of ultrasound clinic under the PC Painity Act.
Separate act is there in state.
Well, that's a central act.
Central act.
It's a central act. In the central act, there is a multi-member committee comprised of 3 persons. In the state, in our state, 1 person has been bestowed with the power to function the same.
Not committee.
Not committee. So we raised that in the writ petition, that particular person is not the appropriate person under the act, which violates the appointment itself. They, in the counter affidavit, has countered relying upon 2 memoranda By virtue of a memorandum, they have bestowed the power of 3 persons to 1 person.
That you have challenged.
That they, since they brought it in the counter, those 2 memorandum,
New grounds that they are your
2 new grounds and 2 prayers, and since they have been passed by different authorities who are not arrayed as a party, it's a conjoint application of amendment.
For amendment and arraignment also. One application you have.
One application.
Whether one application is sufficient in your state. For implement, one application, and amendment, another application is the rule.
Well,
No, I do not know. I am asking you. I do not know yours.
Well, it's in
Two applications.
2 applications were required to file.
But you have filed only one conjoint application.
Conjoint application.
Any application?
No.
So copy is not available in my ear.
A copy is served or not?
So let's file in.
Give one more copy.
I'll give.
File objection because it may change the nature and character of the.
And earlier minutes, the averments to this effect was there in the writ petition. It's not a new, something new.
No, you have taken up those contentions after seeing their counter.
Only those documents.
That's what.
Averments were there.
No, anyway.
I borrowed. I borrowed.
Let them file the
Absolutely.
Lanka is granted a period of 3 weeks for filing objection to the subject application in IA number 6. So, first call in the second week of February 2026. Yes. Item 16.
Let's make a submission. Since 2021, the clinic is shut. Because the ultrasound.
You are enjoying the interim order.
Interim order of operating, but in the meantime, citing this pendency of the writ petition, my renewal application is still.
But without that, you are running now because of the interim order.
Because of the interim order, the difficulty is citing this writ petition pendency. What they are doing is they are issuing a number of show cause notices.
Tell them, show them interim order.
Yes.
On the other hand, we have filed an IA.
Order to continue.
On the other, filed IA for vacation of the interim order.
When did you file that application for vacating?
Yes, we filed in 27/11/2025.
27/11?
Yes, ma'am. Because he filed on 2/12. 2/12. He filed on 2/12/25.
2/12/20.
Yes, ma'am. This one.
So the tomorrow the interim order stands vacated. Read Article 226.
They file an interim application copy.
Copy is not served on you.
I do not have the copy.
Give copy. Where an application is moved for vacation by interim order, and court does not pass order on that within 2 weeks, then the order is deemed to have been vacated. There is such a drastic amendment to the Constitution.
223, 226,
No, 226. Take that application.
Officer.
Just make like this. And the application is filed by the state seeking vacating of the interim order. Is himself appearing for the petitioner this state. First, both the sides want the short accommodation for filing their objections to the respective applications. First, therefore, interim order is continued till second week of February, till the next date of hearing. First, calling the second week of February 2026. Okay. Item 16.
Yes, my lords.
Yeah.
Item 16. I'm for the petitioner. Petitioner was a bookbinder in the opposite party number 2 office. Bookbinder, my lords.
Bookbinder.
Yes. And
Can you cite one scientist who was a bookbinder who became scientist after reading all the books?
Yes, I am reading in my primary stage, but I have forgot that.
Wheelstead. Wheelstead. O-E something like that.
There was a subject that from bookbinder to the scientist. In primary school, I forgot that.
That was Wheelstead.
Yes.
Anyway, yes.
Bookbinder. And he was arbitrarily disengaged in 1994, my lord.
When he joined?
Joined the job in 26 February 1994, my lord.
26 to 1994
My lords.
as bookbinder.
Yes, bookbinder.
Any advertisement selection?
No, my lord, there is director appointment because the rule says like that. That is governed by Odisha government press, industrial employees, classification, recruitment, promotion, condition of service and appeal rule.
Rules are made under which act?
It is not act, my lord. Under
Must be under some act.
Article 309, my.
Proviso to 309.
Yes. Indian Constitution.
Okay.
So
who is the appointing authority?
Opposite party number 2, director.
Under your rules?
Directorate of Printing, Stationery and Publication, Odisha, Madhupatna, Kottayam.
He is the appointing authority.
Yes.
What is the procedure for appointment?
Procedure is the direct appointment. Or direct appointment in the first point of recruitment in all trade will be made in the following manner. Now, there is a national trade certificate.
Following manner means what?
Yes. The number in this category may be notified to the local employment exchange and names of suitable candidate obtained.
From the local employment exchange.
Yes.
You were sponsored by the employment?
Yes, my lord. They have no dispute to my employment.
I am asking.
Yes.
Whether your candidature was sponsored by the employment exchange?
Yes, yes. Because there is a list, my lord, National Trade Certificate, NTC. According to the list, as per vacancy, they have appointed.
No, my question is very specific.
Yes.
Whether your candidature was sponsored by the state employment exchange.
No, in that record, I have no data.
Nothing like that.
But it is written by the counter also, as per the NTC, National Trade Certificate. He is a trend binder, trend book binder. So
National
trade certificate.
Trade certificate. Who issues that?
That there is All India Trade Test, AITT.
It is under which act?
National Council for Vocational Training, NCBT is a
under which act?
That is not mentioned, my lord. Only National Council for Vocational Training, NCBT, has conducted All India Trade Test, AITT. And as per successful candidate, they have prepared a list. And
list was prepared on which date? Who prepared it?
NCBT, my lord.
NCBT?
Yes. So I am 1991 batch.
NCBT list dated?
No, my lord, that list is not on the record. Only it is 1991. It is not disputed by the opposite party number 2.
No, I am disputing.
No, my lord. Yes. So, and in section 11 for subclause, it is written that preference will also be given to those who have acquired more practical experience by working the trade after completion of their training course. That training course means the NCT, National Trade Certificate.
No, thereafter what happened? In 1994,
yes.
You gained entry.
Yes.
Then why are you here now?
Yes, they have
removed.
Yes, ma'am.
On what ground?
Without any ground, my lord. Only ground is that lesser workload and non-availability of funds.
Non-availability of what?
Funds.
Funds.
Yes.
Is it a government department?
Yes, ma'am. Government.
Where our gazettes are being published and all forms of government.
It is government printing press.
Printing press.
Yes.
Printing press is part of the government department.
Yes.
Now, how can you say that you don't have funds?
No, he was initially engaged on daily wages basis.
Is it?
Yes, ma'am.
That you did not tell.
Yes, sir.
Daily wage basis from 26 February.
My advantage, my lord, I have challenged it in Odisha Administrative Tribunal because person who have later engaged after me, they have been regularized. That is the point, ma'am.
What happened to your, you went to OAT?
Yes, OAT.
For regularization?
Yes.
What the OAT said?
OAT told that if there is a similar situated candidate have been regularized, then consider the application of the petitioner.
That application they rejected?
They have not considered.
They are not considered.
No, then
so instead of that,
again I approached the OAT. Then second order,
OIT said the same thing, that his case may be considered. Then they have rejected my representation.
Your OIT.
Yes. First OIT order, my lord, page number 80.
Order of the OIT,
Yes.
he was allowed to continue in service. After disengagement, he approached the tribunal and the direction of the Honorable Tribunal.
My lord, page number.
He was allowed to continue.
Decision is taken on his application for regularization.
My lord. No. Only see the order 2023. 20 piece.
OA application, what is that called as? Application number or what?
Yes.
1059C of 94.
My lord, page 22.
No, I'm just asking.
OA 3187, latest OIT. There is, I approached twice.
First is, what is that OA number?
First one is.
There is no culture in your bar to bring the palm chit.
Yes, sir, I have already taken that for but the case number is not 2082, my lord.
First one.
Yes, 2082. 96.
94, what happened? 94, 105994. OA number 1059C by 94.
96, 96.
94.
94.
Yes.
That was for regularization.
That challenge the termination order. That is disagreement order.
No.
Then another way file 1714 by 94.
How many ways? One is 2082 of 96.
Yes, my lord.
It is for what?
For regularization. Challenging the termination order.
Your regularization case number, give correct number.
OA number 3187C 1998, my lord. It is for challenging the termination order.
There are two more OAs. You said OA 2082 of 96. And he said OA 1059 of 94.
Yes, in your counter we have given.
So in that was for what?
That's not
OA 1059 of 94 was what purpose?
No, that is not on my record, my lord.
You have not been served in counter.
No.
Huh?
No, 96. 96 is there.
Counter paise na nahi?
Counter page.
Acha counter document.
Yes.
In that counter they have said.
Yes.
You should file counter and you should go home to give tuition also.
No, my lord, sir, that is regarding the challenging the transfer order. That is the transfer order. Challenging the OA.
Paragraph 8 of my counter, your lordship,
Yes.
it is humbly submitted that due to lesser work and the term of engagement of the petitioner was discontinued with effect from 6/4/94. The loss of the Honorable OAT passed in OA number 1059/94 and MP number so-and-so, he was allowed to continue as such till finalization of case by the office order number 538 dated 17/94. Then thereafter, he was posted to branch office Deogar by the office order number so-and-so dated so-and-so and by the annexure 3 to the petitioner. Consequent upon interim orders passed by the Honorable OAT Bhubaneswar, OA number 1714 by 94 and MP number so-and-so of the office dated 28/7/94 was kept in abeyance and he was allowed to continue in main press at Cuttack.
That is against transfer order. That is in page number 15, my lord. They have transferred me and other bookbinder. Then I have approached OAT. OAT given a stay order. Then I will continue. That is not about the continuance of service.
Regularization.
Yes.
So it is a continuity of the regulation.
My lord, that is against transfer order.
You continue.
No, my lord, page number 15 is clear.
By virtue of the order of the tribunal, you are allowed to continue. Now you are claiming for regulation. And which is against you.
No, my lord. That is misleading the court.
Misleading?
Yes. My lord, page number 15. That is OA number is written. It is against the transfer order. That is the separate case. That is only transfer. But for the challenging the termination order, I have filed a OA 2082C 96.
1 second.
Page number
Your
18.
termination order is dated?
Termination order dated. That is 27 of 94.
You are appointed in February 94, in August 94 you are removed.
Yes.
And but thereafter you were continued by the court order.
No.
He says in his objections that he has been continued.
Then if they give the approved, my lord. Otherwise, I am not in service.
Now, how long he continued? Till what period? Because you have taken up that contention in your objection.
That's not transfer, my lord.
You are continued in service pursuant to order of the tribunal.
Only
and in miscellaneous.
No, my lord, that is the misleading fact. Only 27 August I have the last working.
27 August 94.
Yes.
Then you have no case at all.
Yes, I have the case because similar situated candidate have gotten the regularization in that post.
Your
On the
affidavit has been filed by the
my lord, I have
joint director.
Yes.
In the level of joint director. And he has not filed any reason or refuting this paragraph.
That goes against you now.
Yeah.
He is not able to exploit it by his advocacy skills is another thing.
Yes.
That goes against you. You say
yes,
he has been continued.
Yes.
Pursuant to particular order.
Yes.
How long he was continued? You have improved the case of the petitioner enormously by your stand, and it's very appreciable. He, according to him,
by virtue of the tribunal's order, he was reinstated in service.
Correct.
Then he was transferred to Deoghar. Again, he approached the tribunal.
Got the order.
Yes, got the order. And thereafter, he was brought back to the main office at Cuttack. That is page 4 of my counter, your lordship, in the top.
Understood.
Then,
Till what was the last date he worked in your premises? Is it your case that he is terminated or he is not terminated?
Terminated and
when?
Disengaged and
with effect from which date?
94 months.
How can that be? It cannot be.
On 26 to 90.
Para 7 of your counter which you have read 5 minutes ago.
Yes. Eligible species by letter number so-and-so in 18 to 94 and posted to forms unit by the office member number so-and-so dated 26 to 94 without taking his seniority in the panel list so-and-so. Then he was disengaged in 6/4/1994.
Read further.
Thereafter, he approached the tribunal and by virtue of the order.
Come to page your last 2 lines of para 8.
Yes.
In para 9, my lord.
Para 8. Consequent upon interim order passed by the Honorable OAT Orissa, number 1714/94, the office order number 597 PSC dated 28/7/94 and he was
allowed to continue
in
the main letter with effect from
6/1994
until further orders.
Yes, sir.
Which is that further order? You have continued it. Though he has not haphazardly has drafted his petition, you have enormously improved his case. What is that until further orders? What was the further order made?
Affidavit does not indicate any further disengagement order.
But how that should work? If it does not indicate, can the judge say, affidavit does not indicate and therefore I am not able to decide this case?
No, that's not. You Lordship may call it next week. I will return.
No, my lord, paragraph 9, it is indicated.
Paragraph 9 of?
Their counter. The yes, the averment made in paragraph 6 of the writ application are false, baseless, and ever denied. It is only submitted in view of lesser workload and non-ability of funds to pay daily wages. The petitioner was disengaged with respect to 27/8/19.
No, that is subsequent to that there is another order.
Yes. So let me call any day.
Already December is about to superannuation, so.
Thereafter, he filed way for regulation of his.
No, my lord, that is challenging the order. I have filed the way. That is there in my writ petition also.
Hey, brother, you para 12, you have not read both you have not read your own papers.
Yes.
You want everything to be read by the judge himself. But the judge has many cases. Up to 2017, things move. Go to para 13. No, it goes to 19 February 2018.
Yes, that is my point, my lord. That is why Odisha Administrative Tribunal directed him to consider my application. In Odisha Administrative Tribunal, I have challenged the only.
All right, read and come back with the short notes. So many dates and so many events, all inconsistent.
Kindly give me 5 minutes, my lord. I will appreciate with the court.
All right.
Yes.
I am asking you when you last worked.
Yes, that is my same answer, my lord. That is 27/8/1990.
But then I have to dismiss your petition.
No, my lord, I will.
It is less than 6 months.
Yes, my lord.
It is less than 6 months from the date of appointment.
Yes, but my other matter.
Long service, even under Uma Devi.
Yes, on that point they have not challenged my.
No, let them not challenge. But court has to look into Uma Devi, whether you want to look or not. Court has to look into it. The decision of the apex court.
Yes, my lord, because similar situated candidates have already been appointed there and regularized. And there is on the record there, my lord.
Your statement that August 1994.
Yes.
He was removed.
Yes.
Then you have no case at all.
Because I have. Wait, my lord. Wait to consider directed to consider my application.
Read and come back in New Year. Let us see some intelligence made dawn.
Yes.
In the second week of February, for both the sides to prepare and argue the matter. Since their assistance is wanting. Yes.
Yes, my lord. Obligement.
You finished item 17.
Item 17 may plead, my lord. The present writ petition has been filed challenging the issuance of the appointment order under file. There are 2 writ petitions.
Rest of the matters we will take up tomorrow. Okay.
Oh, bless me.
One part. 50 is there.
50.
Pass off is there. Just pass.
What can be done? He is not here, na?